Recording in progress.
Пару організаційних питань, поки ми збираємось і займаємо свої місця.
Good morning. While we are taking our seats, I will make several announcements.
Шановні учасники, я запрошую всіх
Dear
зайняти свої
participants,
місця.
I invite you all to take your seats.
9:30 і ми маємо
It is
розпочинати. Доброго всім
9:30.
ранку!
We must start. Good morning, everybody.
Доброго всім ранку!
Good morning.
Пару організаційних питань від
A
організаторів
couple
перед
of
початком.
logistical
Ви знаєте, що ми працюємо в
announcements.
тих умовах повітряної тривоги.
You
Тому
know that we work in
коли це
conditions
неможливо,
where
в разі,
air
якщо
raids
ми чуємо
alarms
сигнал
may
повітряної
happen.
тривоги,
Whenever it
Ми
happens,
наші
when we
допоможуть
hear
всі
this
переміститись в шелтер
signal,
в
the
зв'язку з
assistance
засобами
will
безпеки, якими ми
help you
маємо
all to
дотримуватись.
move to shelter
Я
according
дуже
to the
дякую, що ви знайшли
rules
час
of
до нас
safety.
приєднатись. І
Thank you very much
відповідно
for finding
оголошую
time to
початок
join
нашого
us,
форуму.
and I announce the
На
beginning
початку
of
я
our
запрошую пані
forum.
Марту Мачульську.
First of all, I invite
Почитати
Madam Marta Machulska
вітальних слів. Дякую.
Дякую.
with
Доброго ранку,
welcoming
шановні
words.
колеги.
Good
У мене
morning,
є
dear colleagues.
приємність розпочати вже
I have a
12-й
pleasure to
міжнародний форум
start
з практики
the
Європейського
12th
суду з прав людини.
International
Трохи ми
Forum on
гостюємо
the
у
case law of
Києві.
the European Court of
Мені
Human
приємно
Rights.
бачити
This year we
обличчя, які
hold it in
щороку
Kiev.
відвідують
I'm
цей
pleased
форум, і,
to see
звичайно, щоб
faces that
познайомитися з
attend this
новими
forum every
учасниками.
day, and I
І
will be glad to get to know new
підкреслю, що
participants. I want to
Міжнародний форум з
emphasize that
практики Європейського суду з
International
прав
Forum
людини,
on Case
який
Law
нам
of European
триває
Court of
вже
Human
дуже багато
Rights
років. Ми бачимо його
is
результативність
held for
і
a number of
незмінно
years,
одним
and
з
we
наших
see big
партнерів
results.
є Верховний
And
суд.
our
Саме
permanent
тому я
partner
з приємністю
is
запрошую
Supreme
до
Court.
вітальної
Therefore, I am
промови пана
pleased to
Станіслава
invite Mr.
Кравченка,
Stanislav
голову
Kravchenko,
Верховного суду.
President of Supreme Court, for the welcoming address. Dear colleagues,
Доброго ранку, шановні колеги.
good morning, dear colleagues.
Традиційно починається з того, чи працює мікрофон, чи не працює.
All welcoming words start from the saying whether microphone is working or not. It's okay, microphone is working. So first of all, dear colleagues, on entire staff of Supreme Court and from entire judiciary community of Ukraine, I welcome you sincerely at this event. First of all, I want to thank our partners, OSCE Support Programme for Ukraine, Project Safeguarding Human Rights through Courts Phase 2, Council of Europe Project Support to the Functioning of Justice in the War and Post-War Context in Ukraine, Fostering Human Rights in the Criminal Justice System in Ukraine, and Strengthening Judicial and Non-Judicial Remedies for the Human Rights Protection of the War-affected people in Ukraine. Law Department of Lviv National University, National School of Justice, for helping to organize this event. It's true. Marta Malchulska said quite correctly. Supreme Court for many years is paying great attention to judgments of European Court of Human Rights. Why is it happening so? All those present know that for more than 27 years, Ukraine has exceeded European Convention of Human Rights. According to Article 9 of Constitution of Ukraine, international agreements ratified by Ukraine become integral part of domestic legislation. In particular cases, we may discuss these things. As regards European Convention of Human Rights, everything is for sure. If you look at any serious judgment of domestic courts, you will hardly find a decision of the court without reference of the position of European Court of Human Rights. When Criminal Procedural Code was adopted in 2012, you can find that certain provisions are just excerpts from judgment of European Court. So these are the trends, and practice is changing. It is reflected in national legislation, and I can say that our domestic legislation and judicial practice were developing, in particular due to European Convention of Human Rights and judgments of European Court of Human Rights. Supreme Court of Ukraine for several years is conducting analysis of judgments of European Court of Human Rights, share them with other courts, and they use it in their decisions. But we are facing another very important stage. You know, one of the most significant events still in 2023, and in this year, Ukraine is preparing and conducting negotiations to exceed big European family, accession to European Union. Representatives of Supreme Court are taking part in the work of a relevant commission that in September this year was working in Brussels, conducting screening of domestic legislation regarding reforms that Ukraine should take for completion of this process of accession. We are proud that in conditions of war, judicial system is not only continues working, but continue using standards of European Convention of Human Rights and European Court of Human Rights in its practical work. However, within the framework of this process, we saw considerable coincidences in the approaches used in European Union and in the judgment of European Court of Human Rights. Working with Convention, we are moving our legislation to the standards that have been declared and we must achieve. I want to share you information about other pleasant events. This year, on the initiative of European Court on Human Rights and Council of Europe, and my special thanks for that to Mykola Natovsky present here. You know, he is the judge of European Court of Human Rights from Ukraine. I thank him for the initiative regarding judgments of European Court, initiative that was to create a system that allows Ukrainian judges to choose relevant practice of European Court, that we can get rid of problems where they exist. The issue of relevance or non-relevance at national level appeared because the case law of European Court is used very broadly, but relevant to see whether it suits the particular case. In Supreme Court, we pay great attention to it. We allocate special staff members who are working on that. We are working actively, and I hope that next year we shall submit results of this work, and that will facilitate the work of all judges. From all those events that I mentioned, each step is extremely important. This is our progress in accession negotiations to European Union and important for development of domestic legislation. I'm sure that two very fruitful days are ahead. I wish each of you success. I hope you will get new knowledge, new success, and will share your experience at this event. Thank you very much.
Дякую, пані Станіславе.
Thank you,
Дійсно, ваші слова
Станіславе.
підтверджують
Your
актуальність,
words
необхідність
confirm
проведення
importance
таких
and
заходів.
relevance of holding
Хоча ідея
fora
форуму
like that.
родилася в
Although the idea of forum originated in our university, but still in the process, it acquired support of international partners. And I'm glad to invite First Deputy Rector of Franko National University of Lviv, Andriy Hildyuk. Unfortunately, he will be online. Good morning. Again, traditional question. Can you hear me?
Буквально кілька хвилин чи секунд для підключення. Бачимо, що долучилися.
Several seconds. We have him. Marta, can you hear me?
Зараз секунду. Певні технічні
Just a
питання зі
second. There
звуком.
are some technical problems
Бачимо,
with
що
the
Андрій
sound.
долучився до нас.
We see Andriy Hukaluk. He has joined us, but we cannot hear him.
Як завжди трапляються певні технічні питання під
Such
час
technical
онлайн-формату.
issues
Але ми
happen
зараз
when you work in
швидко їх
online
спробуємо
format, but
вирішити.
we shall try to resolve them quickly.
Насправді, той факт, що дійсно форум має
fact
університетське
that
коріння,
This
підтверджує
forum
те, що в них існує
originated in the
синергія наук та
university
правозастосовчої
proves
практики.
that there is
Так,
a
і
synergy between
підтверджує
academia
питань, про які ми з вами
and
сьогодні
law
будемо
enforcement
розмовляти.
practitioners
І на нашому форумі
regarding
присутні і
issues that we
науковці, і в тому
discussed
числі
today. We have both
студенти,
representatives
які
of
захоплено
academia
приїхали на
and
форум для того, щоб
students that
побачити
were
дійсно,
enthusiastically coming
як
to this
відбувається це
forum
обговорення.
to see live how such discussions are happening.
Знову ж таки, бувають різноманітні технічні труднощі, які ми швидко вирішимо.
Different
На
technical
жаль,
problems happen.
ситуація деколи буває непередбачена. Разом з тим,
Sometimes situation is
треба ще декілька
unforeseeable,
вітальних слів
but
також в онлайн-форматі
we
і
have
в офлайн-форматі.
several
З вашого дозволу,
other
я
welcoming
передам
addresses online and offline.
доповідачу. Запрошую
With
до
your
слова
permission, I give the
Мачея
floor
Янчака,
to
голова
Maciej
Офісу
Janczak,
представника
head of the
Генерального секретаря
Office,
Ради Європи з питань координації програм
representative
співробітництва
of
Ради Європи.
Council of
Будь
Europe's
ласка.
Secretary General, please.
Good morning. Sorry, colleagues. I see that technology is not on our side this morning, but I'm sure we will be able to overcome this little problems. Dear President of the Supreme Court, dear representatives of the Lviv National University, representatives of the Organization of the Security and Cooperation in Europe, dear Judge Gniatowski, dear participants of the 12th International Forum on the Caselaw of the European Court of Human Rights. I am honored to open this forum, an annual event organized by the Supreme Court of Ukraine, the Lviv National University, and the Council of Europe. As the head of the Council of Europe office in Ukraine, I would like to emphasize that Ukraine is investing commendable effort, not only to repel the attacks of the aggressor state on the battlefield, but also to reform its legal system, strengthen democratic institutions, and implement the rule of law. This is indeed impressive and deserves our respect. The Council of Europe supports Ukraine in this struggle to promote European standards, and our office in Ukraine plays an important role in this process. The efforts of the authorities and the society are tangible. So it is only logical, and we try to pursue this path, that our presence in Ukraine expands. In fact, when I arrived here last year, there were only 65 of us. Now there's over 100 people working on different projects for the office in Ukraine to support the country move forward, build its resilience, and to be better adapted to the challenges ahead. I would like to mention that this forum is supported by 3 Council of Europe projects, one of them on fostering human rights in the criminal justice system, the other strengthening judicial and non-judicial remedies for the human rights protection of the war-affected people, and the judicial project. At the same time, the development of Ukraine's legal system is in fact in the focus of most of the projects which are conducted under the Action Plan for Ukraine, which goes under the title Resilience, Recovery, Reconstruction. And in fact, the Action Plan currently comprises over 37 projects, and this number is likely to increase. Dear friends, while recognizing that the implementation of the rule of law in a country is a joint effort of all relevant state bodies and the society, the judiciary, the law enforcement agencies, and the parliament play a special role in this process. I would like to express my gratitude to the truly effective cooperation with the Supreme Court, the National School of Judges of Ukraine, and the High Council of Justice, as well as the Parliamentary Committee on Legal Policy and the Prosecutor General's Office. Let me give you a few examples of the work that we do, which is relevant, I think, for this forum. I wanted to speak a little bit concretely about the achievements which we have been able to arrive at in the past year or so, because, you know, it's important to realize that the Council of Europe is not only about creating standards, it's not only about monitoring the implementation of these standards, such as the Convention on Human Rights, which we will speak extensively later on, but also about helping the country achieve its goals in reaching these standards. And this is what we do in our office. And I think it's important to speak a little bit also about that. Let me start with the project on fostering human rights in the criminal justice system in Ukraine. The Council of Europe supporting the office that has been supporting the Office of the Prosecutor General in establishing a coordination center for victims and witnesses support. This initiative is aligned with the ongoing assistance provided during the war, as the center requires international support for institutional capacity building and essential technical equipment to operate effectively. Recently, a strategic session was held to advance this work. Our project also offers expert advice to help develop measures that ensured verified information on victims of war crimes while promoting coherence amongst domestic registries and inventories. The project also provides support to both the Office of the Prosecutor General and the self-governing and disciplinary bodies, including the Council of Prosecutors and the Qualification and Disciplinary Commission. This summer, we developed a very active collaboration on analyzing the implementation of the Public Prosecutor's Service Development Strategy for 21-23. We also work together on developing the next priority areas for the development of the prosecution. Just yesterday, our experts held a series of meetings with these authorities, the Training Center for Prosecutors and the Office of the Prosecutor General, aimed at providing technical consultations and expert assistance for further reform of the system. Additionally, an analysis of the practice of the Qualification and Disciplinary Commission has been prepared, and we are waiting for the new composition of the Commission to present the conclusions of this analysis. In the framework of the projects on support of the functioning of justice in the war and post-war context and the strengthening judicial and non-judicial remedies for the war-affected people, the Council of Europe effectively cooperates with the Supreme Court. The Supreme Court is among the key institutions to ensure war-affected people rights protection in cases of war-related damage. It's worth noting that the legal issues arising in disputes on compensation for damages caused by the Russian Federation are extremely complex, given the need to consider the interrelation of international and domestic legal order. In 2023, our projects delivered an analytical review of a practice of national courts in cases of compensation for damage caused by the Russian aggression. The national court approach in this regard also was included in this process. It provides a solid basis for further discussions and professional exchange in this field. This year, a study visit of the judges and representatives of the National School of Judges of Ukraine to Bosnia and Herzegovina and Croatia was supported to exchange information on practice in reparations for the war-affected people. Dear colleagues, the Council of Europe projects on judiciary operating in Ukraine are ready to render further expert support in developing the national court practice in line with the Council of Europe standard. This is of crucial importance, since the European Convention of Human Rights is to be applied also in the context of war, naturally with due regard to respective derogations. I would also like to stress that our project on remedies for the war-affected people implements a number of activities on improvement of the national legal framework and data collection on effective remedies for the war-affected people. It also works on strengthening judicial remedies and facilitating access aid for the war-affected people. Our projects, in partnership with the National School of Judges of Ukraine, recently organized a visit to Croatia, Bosnia, working group preparing a comprehensive training course for judges on compensation for damages caused by the aggression against Ukraine. We provided comprehensive support in enhancing non-judicial protection and restoration of human rights for affected population. In particular, enhancing capacities and coordinating among national hotlines for IDPs and war-affected people, supporting the Office of the Ukrainian Ombudsman in addressing the challenges caused by the aggression against Ukraine, educating law students on human rights protection in the war and post-war context, raising awareness of the war-affected people on existing remedies, support programs, and compensation tools. It is also worth mentioning that since 2016, the Council of Europe continuously provides assistance to national partners in developing and implementing the compensation schemes for war-related housing damages. Dear colleagues, let me reiterate that the Council of Europe technical cooperation projects implemented under the largest and the most ambitious Council of Europe action plan ever tailored for a single country remain your reliable partners. Also, or even more so, in particular, during these dark times of the Russian aggression. We are united for peace, sustainable peace based on justice, and we shall remain so, working actively with all our partners in Ukraine. Thank you very much for your attention, and I wish us all a very productive forum. Thank you.
Дякую, пане Мачій, за підтримку України правових реформ, які, безперечно, були би...
Thank you, Maciej, for the support of reforms in Ukraine that otherwise would have been much more complex and much narrower, but for your support. Now we see Andriy Hukaluk on the screen, so we wonder if he can speak right now. Good morning, everyone. Can you hear me now? That's the question to the audience or to the moderator. Can you hear me? It seems they can't, unfortunately.
Пане Андрію Федоровичу, ми вас слухаємо.
Mr. Hukaluk, we can hear you now. Yes, we can hear you. Good, thank you. So, esteemed participants, representatives of the judiciary, dear colleagues, participants of the XII International Forum on the enforcement of... Oh, no, sorry, we can't hear you still. We can hear the interpretation, but not the original. We can't hear the Ukrainian And now we are trying to address this technical glitch. We also have an word online, but not offline. Now I would give the floor to Tatiana Fuley. She's chief of the research department of the National School of Judges of Ukraine, which is our long-standing partner in these fora. Tatiana, the floor is yours. Thank you, Martha. Yeah, the school is indeed a long-standing partner of this forum. According to the program, I am to speak tomorrow. So now I speak in a different capacity, and I represent the rector of the National School of Judges. It is my great pleasure to forward his welcoming words. The European Convention of the Human Rights introduced the judicial mechanism for the implementation of the general standards of human rights in the member states of the Council of Europe. And the Committee of Ministers as a monitoring body, as well as European program on education for the representatives of legal profession, are true examples that are not that numerous when it comes to the conventional mechanism created by the Council of Europe. The entire conventional mechanism, including the protocol to the convention, represents an example of forming of the supranational systems of principles and approaches to the protection and promotion of human rights and basic freedoms. The conventional mechanism has affected also the national systems of law, particularly when it comes to the general measures that were about introducing amendments to the national legislation and forming the necessary practices to protect human rights through the judiciary. In many countries, it is about norms, not only of the convention, but of the national legislation. And the National School of Judges is the institution that implements the general measures implemented by the law of Ukraine on the application of the case law of ECHR. And it means to establish the basic prerequisites for the training of high qualified cadre for the judiciary system.
National School of Judges is organizing training on case law of European Court and European Convention, not only theoretically, but including it into a number of lectures on specific features of particular groups of cases to use practically oriented training methods. Judgment of the court for this training are selected from those that come from government agents on the European Court of Human Rights. This year we have received some 70 judgments like that. Unfortunately, these judgments show broad range of problems that remain topical for quite a long time that impacted the entire system of education. We created educational products that were included our regular training, but help courses is an integral part of training in the sphere of justice. With respect, Rector Mikola Onищук. Thank you, Tatiana, for giving us welcoming address of Mikola Melnik. We look forward to hear your presentation. You are a regular participant of our annual forum. While technical testing is finalizing, I shall invite another person who inspired this meeting, with whom we work often. Natalia Stupnitskaya, Head of Democratization, Good Governance, Rule of Law and Human Rights Component OSCE Support Programme for Ukraine. Thank you, Marta, for warm words. Esteemed President of Supreme Court, esteemed colleagues, partners, I welcome you at the 12th Forum on Case Law of European Court of Human Rights. I'm pleased to say that from the very beginning, 12 years ago, when Franko University in Lviv originated that, this forum became a traditional platform for discussing case law of European Court of Human Rights and European Convention by broad legal community of Ukraine. This forum will devote it to subsidiarity principle as it is interpreted by European Court. We shall discuss domestic legal practice to compensate for damage caused by war, legal education as important component of justice system, and many other important issues. In the recent years, despite all difficulties connected with armed aggression of Russian Federation against Ukraine, many positive changes happened in judicial system. Continued access to justice is provided, the reform of legal education continues. And the main support program for Ukraine by aim is strengthening no input.
Хочу сказати, що сьогоднішній захід цінний праздник
Sorry, but there is a very low level of sound for the interpreter in the internet. Our cooperation with Supreme Court, National School of Justice, training were organized for a great number of judges. Sorry, it is impossible to translate. Very bad sound. Very bad sound.
Це в першу чергу київські рекомендації щодо незалежності судочинства. А в минулому році, наприкінці минулого року, були оприлюднені варшавські рекомендації щодо незалежності судочинства та суддівської бездвірності. І варшавські рекомендації, зокрема, стосуються питань функціонування рад суддів та органів суддівського врядування. Питань свободи вирішення поглядів і свободи об'єднання суддів, а також просування гендерної рівності в органах судової влади. В київських рекомендаціях, зокрема, йдеться про необхідність включення практичної складової правничої освіти.
Recommendations say to include practical component in the system of judicial education. We also cooperate with other law schools, renewing the text, improving teaching methods. We also work with the National Agency of Ensuring Quality of Legal Education. Using this opportunity, I want to thank School of Judges for their cooperation. I wish all participants, representative judicial, state institutions, and self-governed institutions, I wish you all fruitful discussions. Thank you for your attention. Thank you for support of this reform. Now we shall try to hear Andriy Gukhaluk again. Once again, we shall get connected and hear welcoming addresses representatives of Lviv University.
Так, доброго дня втретє. Чи чути мене зараз?
So, good morning, third time. Can you hear me?
Доброго дня ще раз. Вітаю вас.
Good
Ми
morning.
спробували вирішити всі
Mr. Guvalik, we try to resolve problems with the sound. We want to hear your welcome words as representative of Lviv University. Thank you. Esteemed ladies and gentlemen, there is no sound in the room, but you can hear it from the headphones, and participants online can hear it, and interpreter can hear it. Good morning, once again, dear ladies and gentlemen, representatives of judiciary, dear colleagues, dear guests. Traditionally, XII International Forum on Caselaw European Court of Human Rights connects representatives of different spheres, both from Ukraine and abroad. Representatives of judiciary, representatives of international organizations, Council of Europe, OSCE, European Court of Human Rights gather together, as well as representatives of academia and leading institutions that educate legal professionals. The main tasks of participants is to discuss implementation of European Convention of Human Rights in Ukraine, independence of judiciary, integrity and professional ethics of judges, and compensation for damage caused by war. In our opinion, one of the most important task is to ensure quality legal education. Quality training of legal professionals will help to resolve all the problems and all issues that system requires. Lviv University, being one of the organizers, is taking active part in developing judicial system and raising quality of legal education. We see the titles of the section of today's discussion. Rule of law starts from quality legal education. It's very inspiring, and participants who will discuss it, their names prove us that training of legal professionals will be organized at very high level, taking into account requirements of the time, according to the standards of Council of Europe and standards that are enforced in Ukraine. I want to wish all participants of the forum successful work and all of us peace and victory. Glory to Ukraine. Thank you, Andriy, for your nice words. It's my pleasure to give the floor to other representatives of Lviv University. Dean of the Faculty of Law, Professor Volodymyr Burkin. Can you hear me? Can I speak? Yes, we hear you. Wonderful. Good morning, dear colleagues. First of all, I want to thank organizers of the forum that this wonderful tradition to say welcoming address to such important participants. For security reasons, this year forum is held not in Lviv, but in Kiev. But I hope next year we shall come back to traditional Lviv format, because autumn Lviv is inspiring you to scientific work and legal work. I look out of the window, see how beautiful it is. When I was thinking about that, I realized how quickly time is moving. It's for the 12th year that we are meeting. There were some breaks, but tasks of the forum has changed Initially, back in 2012, the biggest challenges for Ukraine were consistent, and then we naively thought painless European integration, where European Convention on Human Rights should become the main goal, its implementation into case law and the judgments of European courts, integration, reform of criminal system, reform of legal education as the base for the system. And in the next years, development of events provide us some grounds for modest optimism. But our northern neighbor broke all these plans. They started the war, and they caused the collapse of European security institutions that demonstrated their lack of force in certain cases. But what is good, the tragedy of Ukrainian people did not cross out European tendencies. On the contrary, became a catalyst of European aspirations. In more than 50% of judgments of Supreme Court, there is a reference to European Convention on Human Rights. Local courts also quite often use references to judgments of European Court. Judgments of European Court become a part of educational materials of educational institutions. And as regards Rome Statute, changes were made in the criminal code. We take into account directives of European Union, provisions of which are not taken entirely in the legal system of EU member countries. But new challenges arise that require scientific review through the prism of possible intervention of European Court of Human Rights. I mean responsibility for war crimes, responsibility of the modern military and state leadership of Ukraine, reparations that should be paid, who will pay it, in what volume, and to whom, responsibility of collaborants, issue of jurisdiction of temporary occupied territories, those that temporarily controlled by Ukraine, the territories that are under control of armed forces of Ukraine, and according to legal borders, they belong to Russian Federation. I'm sure that this forum will continue, but the topics on the agenda will expand, going out of narrow understanding of particular judgments of European Court on particular cases. I wish you all peaceful skies, fruitful discussions, and please keep up to security rules of the forum. Thank you.
Thank you, Volodymyr. I've been thinking of the following. It's the 12th forum, but despite its stability, it gets adjusted to the changing environment, both in Ukraine and abroad. It has not been stopped, but either the pandemic nor the war. So it is yet another testimony that it's exactly what we need. It is my great pleasure to give the floor to Ms. Lilia Gottesbrotter, who chairs the Department of the Directorate General of the Council of Europe, and she would also be speaking online.
Esteemed President of the Supreme Court, distinguished representatives of the Lviv National University, representatives of the Organization for Security and Cooperation in Europe, esteemed judges, colleagues, and dear participants of the 12th International Forum on the Caselaw of the European Court of Human Rights, I am honored to address you from the Council of Europe headquarters in Strasbourg, and to join our head of office in Kiev, as well as other distinguished speakers this morning, in welcoming you to this important annual event, successfully co-organized by the Council of Europe, the OSCE, the Supreme Court of Ukraine, and the Lviv National University. As has been noted here this morning, for the last 12 years, this forum has provided a great opportunity for both international and national participants, including the Ukrainian Law Academia, judges in government, to reflect on the developments in the implementation of the European Convention on Human Rights since its ratification by Ukraine in 1997. Today, the forum takes place during the ongoing war, as indeed for the last 2 years. And above all, I would like to take this opportunity to reiterate how the Council of Europe stands united with Ukraine in the face of the Russian military aggression. And let me acknowledge and salute the incredible strength and admirable efforts of the Ukrainian justice system, which continues its functioning in this extreme context. Now, since the ratification of the European Convention on Human Rights 27 years ago, meaningful results have indeed been achieved by Ukraine. Despite formidable challenges, the progress is apparent in significant areas related to democracy, human rights, and the rule of law. And in this regard, the reform of the judiciary is one of the more visible and long-lasting developments. And even during the ongoing war, Ukraine continues to reform its justice system to bring it fully in line with the Council of Europe standards. Now, my esteemed colleague Pavlo Puskar, who participates in the forum on behalf of the Council of Europe's Department for the Execution of Judgments of the European Court of Human Rights, will later today speak about the number of cases on which the Committee of Ministers of the Council of Europe closed its supervision and recognized that Ukraine executed the respective judgments fully. As has already been noted this morning, an important step in the reform of the Ukrainian judiciary, and in particular the bodies of judicial self-governance, was the re-establishment of the High Council of Justice and the High Qualification Commission of Judges of Ukraine. As you all know, these serve as key bodies of ensuring the proper system of selection of judges and judicial discipline, with the latter remaining the focus of the execution of the Alexander Volkov group of cases. Now, after the re-establishment of these judicial self-governing bodies, the next step in the reforms should be the development of their good practice on the basis of Council of Europe standards as concerns the procedures of disciplinary liability of judges and selection of new judges. This is also a necessary condition for building the public trust in the judiciary. It is therefore not a coincidence that a large part of today's forum is devoted to the issues of the integrity of judges and prosecutors, as well as to the grounds for the disciplinary liability. Now, while we have many thanks to deliver from many people for this forum, I would like to express my particular gratitude to Lorena Bachmeier-Winter, who accepted our invitation to take part in the forum and came to Kiev to speak on this particular important topic. Now, one of the issues of concern with regard to the Ukrainian judiciary has been for already quite some time the approximately 2,000 vacant judicial positions, which inevitably negatively affect the efficient and qualitative provision of justice. This is also linked to another issue, the excessive length of court proceedings, and the potential violation of Article 6 of the Convention, registered in the judgments of the court Merit versus Ukraine and Svetlana Nomenko versus Ukraine. It should be noted that in terms of Ukraine's EU aspirations and the related EU accession procedures, Ukraine could be requested to enhance its efforts towards a fuller execution of judgments of the European Court of Human Rights. In this context, obviously, the Council of Europe is in a position to provide the necessary support through its expertise and through its cooperation projects in Ukraine, especially in the cases where the execution requires complex reforms. Now, by implementing the judicial reforms aiming to bring the Ukrainian judiciary closer to the Council of Europe standards, as well as by executing the aforementioned judgments, Ukraine can and should develop a robust and efficient justice system in the long term. The context of war will bring an enormous volume of cases in which the victims of war will seek justice in the Ukrainian courts. And in the long-term perspective, only a strong and democratic judiciary could cope with such a challenge. In the context of justice for the victims of war, I would also like to note the very important aspect of providing compensation for war damages. And in this regard, the Council of Europe established, as we all know, the register of damage caused by the aggression of the Russian Federation against Ukraine, with broad international participation and its offices in The Hague and in Kiev. Representatives of the Register of Damage also participate in this forum. Now, in conclusion, I would like to reiterate that the Council of Europe commends the all-encompassing reforms that have been delivered by Ukraine as part of the transition to a democratic state. And as our head of office in Kiev noted so strongly already, the Council of Europe remains deeply committed to continuing working with Ukraine in supporting further reforms to consolidate the alignment with the European Convention on Human Rights, and most importantly, to support Ukraine through this awful time of war. Let me again express our sincere expression of admiration for your strength and resilience, and note again in closing our unwavering solidarity with Ukraine. Thank you.
Дякую, пані Лілія, за слова підтримки.
Thank you very much, Lilia, for your warm, supporting words, for the understanding of the context in which we operate, and for the support of our aspirations and hopes. And now I will give the floor to Irina Kushnir to moderate the next session. Thank you. Yes, we are passing to session 1 indeed, and it is called Implementation of the European Convention on Human Rights in Ukraine. And it is dedicated to the principle of subsidiarity, and this is the only principle that has been introduced into the convention preamble quite recently, a couple of years ago. The conventional system has been evolving for 60 or 70 years, and all at once, all of the member states decide that the preamble should be amended to include this principle of subsidiarity, and this should be meaning something for the development of the entire convention system. If we speak about the implementation of the convention at the national levels, and one of the notions, magical notions, so to say, is the principle of subsidiarity, of which we have been hearing a lot. But are we fully aware of the essence of this principle in order to operate it properly? So it is my great honor to invite Mykola Gnatovsky, judge of the European Court of Human Rights for Ukraine, and he will be speaking about subsidiarity and process-based review. Thank you very much, Irina. Esteemed Stanislav, Ambassador Janček, Your Excellency, esteemed ladies and gentlemen, it is my great pleasure to talk to you at this international forum. It is a very famous forum, and it is for the first time that it is taking place in Kiev. One of the initiators of this forum and the university that has so sincerely and most gently hosting us for so many years, agreed on the initiative of the Supreme Court, OSCE, and the Council of Europe to refer this wonderful event to Kiev, but I'm sure that the traditions that have been laid in the foundation of this forum will be further developed today here. And I would like to thank those who make it possible. OSCE, Natalia Stupnitska, thank you very much for being one of the founding mothers of this forum, and for the unwavering support of it for the last 12 years. And I am extremely thankful to the Lviv National Ivan Franko University. In this context, I would like to now note that a person who is most closely associated with the notions of human rights, Ukraine, the Lviv University, was Mr. Rabinovich, who unfortunately is late today, and his image and the memory of him and of what he's done to develop the understanding of human rights in Ukraine, and what he has contributed to the image and renommee of the National Ivan Franko University in Lviv will stay with us for good. I would like to thank the organizers for their generosity and for giving me an opportunity to talk to you several times over these 2 days. Now, I would focus on the principle of subsidiarity and what it has changed in the understanding of the human rights. And I here agree with Irina in that the introduction of notions of the margin of appreciation and subsidiarity into the preamble of the European Convention of Human Rights with Protocol 15 that took effect on the 1st of August 2021 could seem as something of a revolutionary nature. And I'm sure that at the political level, it was perceived as our most important and symbolic steps.
However, neither concept of subsidiarity nor the concept margin of appreciation is not something very new. European Court of Human Rights has developed them long ago. If you want to look at the modern definition of this term, you should not look for it in the judgment of European Court. If you look at the judgment in the against United Kingdom in 1976, you will find it. So on the one hand, it is a revolution. On the other hand, it's something which is well known. So people who watch the work of European Court of Human Rights from outside, that I used to belong before 2021, the nominating opinion of all of us, it is symbolic that these concepts were included in the preamble, but nothing will be drastically changed in the work of the court. But when, for the first time, I started taking part in the consideration of cases in the European Court of Human Rights, I realized no changes has happened. maybe they were not so evident. The court will not insist that huge change happened in 2021, but in practice, the main ideas of principle of subsidiarity are the ones that dominate in the process of adopting judgment of European Court. I want to emphasize this process of decision-making, because assessment of the fact whether the state is implemented its commitment to European Convention of Human Rights by European Court is now often happening. It's happening in very many cases. It's difficult to establish. Percentage is probably very high, which is reviewed by chambers and grand chamber. Probably it is taking the most important place. The process-based review. It's not easy to translate it into Ukrainian, that it exactly gives the meaning. It's a kind of procedural approach. This is important from the point of view of principle of subsidiarity. Why it happened so? There are two reasons for that, and I want to remind them. You probably know all them, but they must always go together, as I think. There is an external factor that impacts European Court of Human Rights, the expectations that decision makers have from the court, the leaders of the state, because the court belongs to the states. It's their way to create the system, the uniform system in Europe for abiding by human rights. And the states who establish the court have the right to adjust the direction of movement of European Court of Human Rights, how it is fulfilling its functions. They could be satisfied or not satisfied with what court is doing. Even if some individual expression satisfaction of non-satisfaction cannot be taken very much to the account by the court. They should not probably, but when they reach volume of critical mass, that should be done. So on the one hand, there are expectations from the side of the states. What are the expectations? That European Court of Human Rights will not take away the functions that are reserved for the sovereign state, even those sovereign states who agreed to have very well developed and progressive system as European Court of Human Rights and the bodies established by court, first of all. So the state must have all these well-known margins of appreciation. It's a legislator who must decide on the most sensitive issue, taking into account what voters expect from it. Legislators come to power promising to make certain changes in legislation or not to allow certain changes. Since our joint European system of protection of human rights is functioning in democratic environment, it's impossible to ignore them. Democracy will become full democracy. It is reflected in messages of Council of Europe. Only if it goes together with human rights and the rule of law, then it will be a true democracy, because without human rights and rule of law, democracy will turn into a tyranny, as ancient Greeks has warned us. But on the other hand, a democratic state anyway cannot be deaf to what people wish to get, and we shall not hide it. Relevant politicians, statesmen, members of parliament, they formulated their own impression that European Court is moving them into direction which their people do not want. So they wanted to return control into their own hands to some extent. That pertains to the parliament, administrative decision taken by executive power, and decision taken by domestic courts in the state. On the other hand, this is the external pressure. Internal processes. What are the internal processes? Those who are professionally engaged in the work of European system of protection of human rights realize that this system will be effective only in the case if the system is not separated from the work at the national level. Never. The best court in the world, let us imagine the European Court of Human Rights is the best court in the world, will never alone ensure human rights in any state if it is not done in the first place by the courts of this state. If relevant considerations are not decisive for decision-making by executive power, and if these are ignored by legislators, this is a common responsibility. Another key term that will repeat it all the time. Shared responsibility. You hear it in the judgments of the court. It's a magic term, shared responsibility. But in fact, it is an ideology that it is used. It must be a joint responsibility. Back in 2014, very young at that moment, and seemingly not much experienced Icelandic lawyer, who later became the judge of the court from Iceland, he declared the excess of age of subsidiarity. He announced that at certain economic publications, he felt the zeitgeist. He felt where things are moving. This individual did realize the vector, the main direction of development. He is being criticized quite a lot. Now, it's very much in fashion to criticize him. I must say that my initial attitude to high emphasis of subsidiarity was not very positive. I had very serious reservations. I thought that that works very well for certain conventional freedoms, but they should not be basic when you talk about basic things. Till now, I have serious reservations regarding use of subsidiary approach when we speak about right to life, prohibition of torture, prohibition of servitude, and deprivation of liberty. In these cases, you should not get too much enthusiastic with subsidiarity. You can get to absurd results. The convention was not created for that. Article 7 pertains to that. Article 6 depends. But when you talk about democratic liberties, Article 8, 9, 11, Protocol 1, Article 1, 2, 3, Article 4, Article 2 of Protocol 4, one can talk about it to a great extent. One of the thoughts of Robert Spam was, in Europe, every judge must become a judge of human rights. irrespective of the instant that he's working in, first instance court, appeal or cassation court, a judge that is using methodology of analysis of human rights. This is a judge who is guided by the requirements that have been formulated in the case law of European Court without external interference from outside. And when this is not happening, there are all grounds to believe that there should be external control. And where is a problem, the state will find a violation. I would like to emphasize close connection between the concepts that I had mentioned: margin of appreciation, subsidiarity, joint responsibility, shared responsibility, procedural review, process-based review. That is what works together. That defines how convention is applied in the world, in Europe. Accordingly, there is another interesting aspect. European Court of Human Rights is applying this process-based review by looking in what way the logic of convention was used when decision was taken at national level regarding all branches of power. First of all, it pertains to judiciary, but same way it pertains to administrative decisions and to legislative process. And this is very important. It could sound counterintuitive, but rationale is very simple. Taking any kind of decision which is an interference into human rights safeguarded by convention must have certain elements that necessarily must be resolved when they are resolved properly at the national level. The court, this is the message they will see over its judgment, the court will not substitute national bodies, national courts, national parliament, or national executive bodies. But in the case when the relevant steps are being made, what are the steps? There are two components. First component, the requirement to give relevant and sufficient reasons for interference in certain rights guaranteed by convention. Another cliché of the court, the permanent expression that we must remember: relevant and sufficient reasons. Relevant and sufficient reason. And sufficient decisions. This is first component. The court looks whether the court has taken into account this requirement to explain why it is interfering.
In the cases related to democratic freedoms, we should be looking at whether there is the legal ground, whether it is lawful, whether it is a legitimate aim there, and it exactly means to provide the relevant and sufficient reasons for the interference. Another element, or the other element, which is equally important but which is more complex, would be a requirement whereby such decisions are taken to achieve the balance of interests. Being aware that we've got a legitimate aim that is envisioned by the law, that is reasonable and legal, and it is part second of Articles 8, 9, and 10, etc. of the Convention. On the other hand, we should strike a fine balance with the right into which we thus interfere, and we will see the outcome that we achieve. Whether we are trespassing with our intervention, which is necessary in a democratic society. And I will note here, entre parenthèses, that this idea of the necessity in the democratic society is a European idea. It has been in the convention since 1950, and it has become so predominant in the European law that in 1966 it entered also the UN Pact on the Human Rights, and it is maybe the only case whereby the pacts require that governments are democratic. In Europe, it is a given, but not elsewhere. And through the text of the European Convention, it actually migrated into the UN pacts. So we should be conducting this balancing exercise every time. I know a lot of jokes related to the balancing exercise idea. People speak about ballet very often in this respect, but we have to take into account the interests that are at play here. We should take into account what we are doing and for the sake of what. So I can't say that these are totally revolutionary things and they have taken effect only with the advance of Protocol 15. Not at all. You can find such things in the previous elements of law. For example, I can give you a whole list of cases where the national courts provided relevant and sufficient reasons, and whether they did this balancing exercise, but it makes no point, because if you open the cases coming to ECHR, you will find that everywhere. There are fewer judgments related to the analysis of administrative decisions, but they are there as well. For example, the oldest decision of 2003, Grand Chamber Ketten versus the UK, the case about the noise contamination around the Heathrow airport. It's an old case, but even then, the Grand Chamber analyzed the process of decision-making by the administrative body, not the court. But that was enough. After that, we received a lot of cases like this, and legislation was also intensively and extensively analyzed. And one of the well-known cases is that of 2014, Animal Defenders versus the UK. It was about the ban on political advertising on television, and the animal protectors wanted to be advertised, but their advertisement was banned, and it was about whether the parliament took all of these subtleties into account while passing the law. There were several such cases against Ukraine. Sukhavetsky versus Ukraine of 2006 on the deposit, electoral deposit. And it analyzed how the Verkhovna Rada, the Parliament of Ukraine, introduced this deposit so that some of the candidates, frivolous ones, could be sifted off. So all of that does exist, and these are very well-known things, but gradually they take more precedence in the practice of, say, the Grand Chamber. The very last judgment was in the case LB versus Hungary, the case about the law according to which personal data were published, including the address, home address of those who failed to pay taxes. And the Parliament in Hungary admitted that there was a problem, that they violated human rights. And this is a process that has been on for some time, and it will be developing towards this end, proceeding from the considerations of shared responsibility for protecting and promoting human rights, for respecting human rights. And when judges speak, you always expect that we would be mentioning some very new cases. So when it comes to the analysis of the decision-making processes, a most interesting example can be found in the recent judgment by the Grand Chamber. And this is a case I know very well because I then belonged to a chamber that decided to refer that case to the Grand Chamber. So it is Pindamuya versus Spain. It is a case about the blood transfusion against the patient's will. The blood was transfused to a woman who objected to this because it ran counter to her religious conviction. She is a Jehovah's Witness, so she could not get anything to do with somebody else's bodily fluids. So it was a situation whereby, as a result, her life was saved. You know, eventually her life was saved. But since she had consistently refused to get this blood transfusion, this had to be taken into account. And I wouldn't open any secrets of the court if I say that it's quite evident why it was referred to the Grand Chamber. On the one hand, it looked like the will of the patient wasn't taken into account, and she expressed this will in all possible ways. She kept talking about that. She expressed that in writing, and even before being taken to the operation theater, she insisted she wouldn't get any blood transfusion. So what's the balance? The balance between Article 8 and Article 2, or Article 8 plus 9, including the religious convictions, and how to address that? So what did the Grand Chamber do? They considered the process of decision-making by the Spanish court. As a result, the surgery was carried out because it was allowed by a judge, to which the doctors of this hospital resorted seeking permission. And in Spain, the legislation is extremely progressive when it comes to medical practices, but the judge didn't know the detail of this case, and she knew that the woman was a Jehovah's Witness, but she needed blood transfusion for the sake of saving her life. And all of this analysis has been conducted, and the chamber came to a uniform decision, 17 versus no. So the decision-making process was faulty, and the court insisted that it didn't mean that we would blame the judge who had very little information and had to respond very quickly, but we are speaking about the treatment of the patient. And there is no denying the fact that the treatment was such that ignored her expressed will, and just her wishes and desires were not taken into account, and her ability to have such wishes was not assessed. And if you look at point 2 of the operational part of the decision about material compensation to the applicant, and the Grand Chamber that was unanimous in this part of the decision split 8-9, because they many said that, and that's my reading of this minority opinion, that her life was saved. Isn't that a compensation enough in and of itself? So, but since the conventional right was violated, that certain compensation was due to her. So I was in the majority, so I still stand by this judgment. Thank you. I would stop here. Sorry for taking too much of your time, and I think we now have a couple of minutes for Q&As. Thank you very much. If the National Court of Spain would actually honored her wish, then she would die, wouldn't she? Yeah, it's not guaranteed. You know, if from the very beginning, all of that had been taken into account, we don't know what that would have ended with. With her diagnosis, there was a treatment unrelated with the blood transfusion. Had it been started earlier in the process, they could have saved her life anyway. But they were transferring her from one hospital to another, and they couldn't explain this to the judge in question. And they were taking her to the hospital that was capable of treating her without blood transfusion. But doctors of the hospital eventually decided that it was too late in the process, that too much time had been lost or wasted. Questions? 10 seconds and a question, okay? Can you please use the mic? We will take several questions and then we will break. Evgen Petrov, my question is about compensations. We've got a lot of cases about the land plots. The prosecution office represents the state. Please speak into the mic. Yeah. And there is a question that the prosecution service says that the decisions taken by village council or town councils did not correspond to the requirements of the law, so they could not allocate those land plots. Those land plots have been in somebody's property for 7 or 8 years now. And the question is whether Protocol 1 of Article 1 is violated in this case, and how those individuals should or can be compensated, because they thought that those decisions were correct, but then the court decided that those decisions were wrong. So should the court rule on that independently, or should the applicant make this point expressly? Thank you. Thank you. Another question? Now 3 questions, then answers, and that would be it, okay?
Так. Ні? Працює мікрофон?
Давайте зробимо.
Може, ваш, так.
Ще раз доброго дня, всім доброго дня. Мене звати
Good
Віталій
morning,
Юркевич.
everybody. Vitaly Yurkevich, Secretary of Grand Chamber of Supreme Court. I want to come back to the beginning of your presentation, to principle of subsidiarity. I understand it in such a way. This relevant European mechanism is used when at national level, courts and other authorities made an error. But your opinion is it's not possible to use it to particular articles, and you mentioned them. When such violations happen, what to do with this principle? Esteemed Mikola, I am Martiv Sigrid, Judge of Grand Chamber of Supreme Court. I have a practical question. Please tell us, is there a need of new revision of the case after judgments of European Court that there is violation of the rights, if it is not mentioned into the motivational part? Some compensation is mentioned, but later, whether national court has a discretion to decide, is there a need to review the case again or not? Thank you very much, dear colleagues. Wonderful question. Each of them requires minimum 1 hour of discussion. They are of principal importance. I will try to answer very question, but there will be more opportunities to discuss this. Even this week, we should get together and discuss them. Evgen, your question regarding compensation and revocation of ownership right. This problem is one of the most acute in Ukraine from the point of view of European Court. We have now about 200 cases pending, and their number is growing.
Коли цей проєкт у нас формувався, і ми виробляли, так мовити, нашу стратегію, що ми
developing in the court, we were developing the judgment. We had some 80 cases. Now we have 200. And all that started a year ago. What is the concern? I shall try to explain it diplomatically, since I speak openly. Absence of respect to property rights is one of the biggest obstacles for development of Ukraine as a state. For attracting investors, for the trust of citizens to the state, and for our European integration. The way in which property right is annulled and again explained clearly how prosecutor's office initiated it, they find violation of legislation, and they squashed decision of the court that not only undermines the basis of development of the state, it creates grounds for corruption and risks. I put it diplomatically. This is the question whose significance is difficult to overestimate. It is clear that things happen in the process of privatization. Some mistakes happen, but one should apply the standards that are well known. Article 1 of Protocol 1 of Convention. Interference into property rights should not be unproportional, to say nothing about relevant interests, etc. We tried to start answering this question. First judgment is published last Sunday. Trostick and Mikula versus Ukraine. Probably you meant it. land plots located near railway station. But the problem was not the railway station. There are other reasons, but we call it the railway scenario. One of the most difficult issues that European Court faces, what to do with compensation. What shall we do? Drozdok and Mikola decision proposes new approach. Violation of convention should be removed. But Strasbourg doesn't see it better how to do it. It is the national court must decide in each particular cases what compensation size should be and how this violation should be removed. But I'm ready to continue the discussion. Vitaly, thank you for your question about subsidiarity. You hit the target. Probably what I was telling created erroneous perception. Principle of subsidiarity is effective always. Primary responsibility for human rights is taken by the state, and European bodies help when help is needed. I don't think that this principle is not applied to any category of cases, but this process-based review, procedural review, when the court does not dare to do it, they say, no, we can't do it, other courts should do it. When one talks about violation of Article 2 and 3, tonality and approach should be different. Courts must be more decided because Article 2 and Article 3, they are the basis of all. In democratic society, in any society. Sergei, as regards new revision, we organized big seminar in court on that. I spoke there and I'm ready to send you the text of my presentation there. But speaking briefly, when European Court establishes violation of convention, that means the state has not fulfilled international commitments, and this state is responsible for that. This responsibility is happening by restitution, by returning to the status that existed before. If it is not possible, then compensation is paid, so on. If for that it is necessary to reopen proceedings, make the new review of the case, it is possible. But I think that it is not necessary in all cases. This is discretion of national court. But this is a very serious conversation. Extreme emphasis on discretion can lead to consequences that we do not all like. Ukraine provided the case Bochan number 2. This is our negative achievement, one of the numerous negative achievements. Thank you very much for your questions and hope to continue conversation on other topic. Bochan 2, in my view, is the era that provided huge experience and huge impulse for further study of convention. And thank you all for your questions. Mykola is with us in the course of 2 days. You can ask your questions wherever you meet him, and the issues of arguments, subsidiarity is a breakthrough issue. And now I invite you all for coffee, and we get back here at 11:20. 11:20. Thank you.
Всіх запрошуємо з кави. Я прошу організаторів, наших співробітників всіх запросити.
The organizers, the participants, please could you come to the forum venue?
Я буду стояти. Я тебе побачу, і буду на тебе.
Шановні учасники, які п'ють каву.
Dear participants who are still out having coffee, could you
Ми будемо
please
вимушені прибрати кавомашини.
be here again so that we could
Таким чином
resume our
заохотити
work?
вас до співпраці. Я прошу всіх запрошувати, і ми починаємо.
We are resuming our session.
Так, чути? Шановні учасники, ми всіх запрошуємо до зали.
Dear participants, I am inviting you yet again to come to the Congress Hall.
Ті, хто до нас приєднався, я запрошую зайняти місця. Ми будемо продовжувати.
Please be seated and we will continue
І продовжувати ми будемо
our
з
work.
актуальних тем. На перший
The
погляд,
topics that
якщо
we
ми
are going
подивимося
to
програму,
discuss are
почитаємо всі
extremely
теми, які
relevant.
включені в цю
If
сесію,
we look at all of the
ми
topics
зможемо
included
побачити-
into this topic, into this session, sorry, you will see
Я зачекаю, поки всі доєднаються. Дякую.
Thank you.
Шановні учасники, займаємо місця і ми налаштовуємося на роботу.
Okay, so as I
Насправді, якщо
said,
почитати
you will
теми, включені в
see
першу тематичну сесію, то можна зробити висновок, що вони
that the
абсолютно не
topics of
поєднані.
this session do not
Після права
seem
на життя ми можемо
mutually
сказати, що саме дорогоцінним для
related,
людини, яка має
but
дітей, це діти. І
we
саме
know that
тематика включена в сесію.
children are extremely
Саме
important
дорогоцінне
to
після
all of
життя
us.
це майно.
Life is
Втрата
important, of
майна
course, but
саме
also
таке
property is important.
серйозний
And the
удар
loss of
по
property
людині,
is a
відповідно, ми
very
будемо
serious
говорити про
blow after
свобода.
which a
Свобода
person can
перетину
be reeling for a long
кордонів,
time.
свобода
Then
руху,
freedom
свобода
is
розвитку.
also one of the greatest
Відповідно,
human
всі ці теми
values,
насправді
the
пов'язані з цінностями
freedom
і
of movement, the
найдорожчим, що
freedom
має
of
людина для свого розвитку, для своєї
traveling
безпеки
abroad,
і для
etc.
розвитку
So
своєї сім'ї.
these are the values
Сьогодні
that
вже лунало
we
питання про
all
те,
hold
яким чином
dear.
можна забирати, конфісковувати майно, те майно, яке було
We've been
передано
speaking
незаконним
about the
чином,
confiscation,
недобросовісно чи
alienation of property, and this is exactly what our next speaker is going to focus on. So we are now will be discussing the alienation of property by the state, either by mistake or because of deliberate illegal actions. And we've got a whole set of judgments related to the way the property was alienated. And all of you know that Ukraine is still among those countries that violate the provisions of Protocol 1 to Article 1. And as one of the Ukrainian experts said, that the state property has been divided long ago, and it seems that because of the illegal actions and lack of goodwill on the part of some actors representing this state, there is no remedy available to the society, to the state, to the communities. Is that so? Or is it a false impression? Is this the situation that can be reversed? And we are going to discuss this issue in greater detail right now, so I would give the floor now to Dmytro Gudima, judge of the Civil Court of Cassation within the Supreme Court, and he's one of the founders of this forum that we've been holding for 12 years now, together with the colleagues from Lviv National Ivan Franko University. He was amongst the people who decided to initiate this forum and to formulate the main purposes of our discussions. So Mr. Gudima has got the presentation, and you have got 10 minutes. Please do not exceed this time limit, will you? Yes, of course, esteemed Chair Justice of the Supreme Court, esteemed representatives of the Council of Europe, OSCE, Lviv National Taras Shevchenko Lviv National Ivan Franko University, Kiev National Taras Shevchenko University, Ukrainian National School of Judges. Yes, indeed, we initiated this forum together with Petro Rabinovich back in 2012, and I'm extremely glad that this forum is still alive and that there are organizations willing to provide support to it, and there are a lot of people willing to participate in the forum discussions. The key speech by Mykola Gnatovsky inspired me to consider some of the basic things. He believes that subsidiarity does not apply to the absolute rights, and I do agree with this interpretation, this approach. But this means at the same time that the subsidiarity principle applies to the rights where the state can use certain restrictions, including the peaceful ownership of property. And when we speak about the lack of respect to private property as an obstacle to the development of democracy, it is true, but tolerating the malafide actions by the agents of the state, this should be fought against. And this is the topic that I'm going to discuss with you. It is about this balancing exercise when it comes to alienation of property, be it the state property or municipal property, as a result of the so-called mistakes or bona fide mistakes, or else their deliberate illegal actions. Article 1 of Protocol 1 to the Convention allows for the limitation by the state in particular to ensure control of certain property items in order to protect the societal interests. And today, I would like to consider and to discuss with you a number of examples of how the Grand Chamber of the Supreme Court tried to find this balance of interests. And I will... Sorry, the signal has frozen. One, two, three, four. The signal has frozen. I'm sorry. Sorry about that. There is no signal.
запроваджений механізм реєстрації, то теж застосовується такий 10-річний строк. Більше того, передбачається
Then this 10-year term is also applied. And in fact, it's impossible to claim for the requirement of this property. I can't imagine a situation whereby the claimant, be it the state or the territorial community, could transfer the money onto the deposit, because we are speaking about the bona fide applicant, but the community can say think that the respondent would not be bona fide one. So when the deposit should be required and when shouldn't it is an interesting question. And another thing is the rationale behind this bill. We are speaking about the limitations between the parliamentary activities and that of the judiciary. And as my colleague Natovsky said, the question of balance is the question that is addressed by the court. But if we look at the draft bill, then we'll see that the case law of the Supreme Court about protecting bona fide acquirers or buyers runs counter to Article 1, Protocol 1 of the Convention, or to the Convention. So we can scarcely be speaking about all of the decision of the Supreme Court, and perhaps it should not be a guidance to the amendments to the criminal code when it comes to the protection of bona fide buyer. And when it comes to the balance of interest, we should refer it to courts alone. No other authority can achieve the balance in something that they can't see. The norms established by the government or parliament are of a general nature. So when it comes to the limitations of parliamentary activities, when it comes to balancing interests and how the interest can be balanced by the Supreme Court, that's a question that I would ask of you. Thank you very much for your attention.
Я дякую. І оскільки
Thank you.
доповідь присвячена практиці Європейського суду у
Since
справах про захист прав
your
власності, якою
presentation is devoted to case law of European Court, it will be presented by Alla Kiertz, and her presentation is connected with Dmitro's presentation. Good afternoon, dear colleagues. To some extent, I will follow up what Dmitro was telling about case law of European Court on Protection of Property Rights. We all know that property right is protected at high state level according to Article 1 of Protocol 1 to Convention on Human Rights. As regards judgments of European Court, it's a kind of formula for the court, indicating the criteria that you should have an independent decision whether to accept it, whether to reject. But still, a relevant question remains: which criteria must be assessed by national court? As Mykola Hnatovsky correctly mentioned, there should be shared responsibility, and I fully agree with this. Then, coming back to Article 1 of Protocol 1, it contains 3 separate norms that one should pay attention to. First norm is of general character. It indicates that it is a peaceful ownership of property. Second, it mentions grounds that allows to remove property, and third, it's the state who should regulate ownership of property. All three norms are interrelated, but norms 2 and 3 that I emphasize are viewed in the context of norm 1, taking into account such important principles as rule of law and legal certainty. Of course, this Article 1 of Protocol 1 to Convention mentions that right of each and every person should be protected, right of any physical person, whether it is a national of that state or not. A physical person undoubtedly can expect that his or her rights will be protected, whether that person owns this property as private person or got rights in the legal entity. If we refer to Article 34 of Convention, it emphasizes that a legal person that believes that its rights are violated by Convention and its protocol, it may ask for protection if it is a non-state organization. You should refer to Article 34 in this sense, because Article 1 of Protocol 1 is the only article that directly protects property rights. There are judgments of European courts in the case of Luhansk Holding Company versus Ukraine. The court rejected this application, referring to Article 34, since the application was submitted by the state-owned holding company that was registered as a corporation. It was under control of the state, it was fulfilling functions of the state, and the applications was rejected. That should be taken into account in the future. Article 1, Protocol 1, right of every physical or legal person on peaceful possession of its property means that right of ownership is violated with direct interference, physical interference in this ownership right. Most often, interference in the property of physical legal entity is often happened by the state, by executive authority, sometimes by legal or judicial authorities, by adopting certain legislation or making certain judgments. Case of European Court developed 3 criteria that should be assessed when understanding whether right of property allows legal acceptable interference. Limits of this interference, availability of legal ground, and ensuring equality, equal balance between these criteria. Sorry, it is frozen again. No sound, it is frozen. European Court of Human Rights states that the state violated the norms of Article 1 of Protocol 1. Next, what I want to pay attention to, if the court comes to conclusion, if national legislation is not in compliance with quality of the law, the court states violation, not referring to criteria of other possible violation probably took place. It's enough to conclude the insufficient quality of the law. When analyzing case law of European Court, You should pay attention to such cases when a person is deprived of property contrary to the law. Andriy Rudenko versus Ukraine. Unmotivated judgment. Syrian and other versus Ukraine. Judging costs on the basis of a certain law or unfounded changes in legislation and other grounds. There is no exhaustive list of all grounds.
Переважно дискусійним залишається питання розміру оплати.
Which issue remains debatable? The size of compensation for alienation of property. The issue of compensation. We discussed it today already. It's worth mentioning that there is no generally accepted procedure for defining size of compensation depending on type of property. There is only a general rule based on which the size of compensation must be in compliance with the value of property alienated. If possible, compensation should also take into account other factors. The situation of a private person, social situation, moral damage incurred to a person as a result of removal of property. The court believes that compensation must be connected with the value of the property and not necessarily be in compliance with the market value of the property. Public interest can justify paying compensation less than market price of the property. In the end, I want to draw attention to other facts. In the case law of European Court, they make a difference between paying compensation to a foreign citizen and to its own citizen. Provisions of Part 1 of Protocol 1, according to which no one can be deprived of property other than on the basis of principle of international law. It pertains, first of all, to foreigners that are deprived of property in a foreign state. According to international rules, the state should pay compensation to foreigners for expropriated or nationalized property. This norm is almost not applied to applicants who are citizens of the country. Compensation paid to the own citizens is based on the principle of proportionality. This is a very important principle, proportionality of decision taken that, according to general rule, does not allow to deprive person of property without any compensation. In this context, one can draw attention to exceptions. There could be cases of emergency when property is expropriated in conditions of war or other emergency situations. Thank you for your attention. I'm very thankful to you for very profound description of case law of European Court. Later there will be questions from the room, but in the very end. Now we come to the next thematical issue, which is extremely important, but very, very difficult and hot here in Ukraine. We should hear about case law, the cases. Limitation of crossing Ukraine border. Maybe these cases will be discussed by the court in the future year. But the next presenter has a historical role in this forum. If I'm not mistaken, Lyudmila Yaresko, judge of the Administrative Court of Cassation within the Supreme Court. She took part in the second forum held in Lviv. So at that time, you were not a justice of Supreme Court, but you took part in the second one, and you will speak about the most hot and difficult topic, please. Can you hear me? I want to respond to the comment of the moderator. I am a justice of Supreme Court and support the forum Supreme Court many years ago. My topic is included into the agenda because it's very, very relevant and painful for Ukraine. Freedom of movement is undoubted value. One should not diminish it. In peaceful times, restraint of traveling. Previously, we could not imagine it, but the war started. In conditions of war, laws of peaceful time are substituted by laws of wartime.
When the Supreme Court started accepting such cases, we studied the entire legislative framework that would guide us in our judgments. With the introduction of the martial law in Ukraine, the presidential decree in paragraph 2, amongst other actors, mentions the state border guard service, and it is part of the military command in the country. So what is martial law is a separate question. It's a special legal regime that is introduced in Ukraine or some of its areas to make it possible to protect the country from the military aggression, and it provides for the assigning a military administration, military command, and local authorities the necessary powers to fend off the aggression and to ensure the protection of the state independence and sovereignty, territorial integrity, and also temporary restriction of human rights and liberties, as well as the rights of the legal entities. What does it mean in the context of the war? The military command got a set of broader powers, and when it comes to the crossing of the border, the state border guard service of Ukraine does not act as they usually do in peacetime as a specialized law enforcement authority. In this very case, they get additional powers to apply measures that ensure safety and security of the state. So if we look at the legislative framework guiding their activities, we should focus on this presidential decree on announcing the martial law. It also introduces military mobilization in the country. So the declaration of the martial law and the military mobilization, the special period at the national level ensues. And this special period vests special extended powers in certain authorities. In particular, powers and responsibilities to enforce the measures of martial law. Among those, according to Article 8 on the legal regime of martial law, certain authorities are entitled to establish special regime of entry into the country and exit from it for citizens, for stateless individuals, and for foreigners. Thus, the State Bodyguard Service is an authority of the military command entitled to enforce the measures of the martial law. The discussion on how those measures should be regulated. Should there be a separate law governing the restrictions of the right to freedom of movement? Is yet a toss-up, and the Supreme Court studies these issues proceeding from the law on the martial law and a special period. So our conclusion is as follows. The application of temporary measures based on Article 8 of the law of Ukraine on the legal regime of martial law, and also based on the law of Ukraine on mobilization, preparation and mobilization, according to Part 6, Article 22, whereby the draft age citizens cannot change their place of residence without authorization by the responsible bodies. So the State Bodyguard Service does have legal grounds to take such measures with a certain legitimate aim. The law of Ukraine on exit from the territory of Ukraine and entry to the territory of Ukraine for Ukrainian citizens, Article 3, the rights for the border crossing have to be established by the Cabinet of Ministers according to this law and other laws of Ukraine. So the Supreme Court concluded that it gave grounds to the Cabinet of Ministers to take into account the martial law measures legally introduced by the presidential decree. So while considering such cases, the Supreme Court enforced the provisions that are part of the legislation. It's difficult to object that the unprecedented scale of threat that actually challenges the very existence of the state of Ukraine. So the Supreme Court decided that the priority should be given to the public interest over the individual's interests. So it also concluded that the way of implementation of this measure was necessitated by the protection of the human and material resources, so it was proportional and it wasn't arbitrary. The balance here was ascertained by the court, and the proportionality was also ascertained in an unusual way, where we have to do this balancing exercise between the public interest and individuals' rights, but we were speaking about the constitutional freedom of movement, including the freedom to cross borders. And on the other hand of the balance, there is the constitutional obligation of an individual to defend their country. So the constitutional obligation is as important as the individual right to the freedom of movement. So the Supreme Court decided that public interest and individuals' constitutional obligation prevail here. So, and it pertains to the military service, starting with the mobilization records and the need to be part of those records and the obligation to serve in the armed forces. So my overall conclusion that's the conclusion of the court in this case, was that there was the legitimate aim of protecting the sovereignty and territorial integrity of the state. So the balance between obligation and right was struck in this case. There is another approach whereby if an individual
розуміння, військова служба, вона передбачає багато етапів, починаючи з постановки.
Understands all of these stages of the military service, starting with getting registered, then notifying the authorities about the change of address, etc. So if a person follows all of the rules at all of these stages, and if they have the right to deferment, then as a rule, such individuals can cross the border for certain purposes. And those individuals that were denied this right to cross the border, every time the court reasoned that it was an individual occasion and that on other occasions they could be given this right, provided they produce the entire package of documents so they can enjoy this right under such conditions. In a different case, the Supreme Court used a different approach, whereby the person who was removed from this military registration still was not allowed to cross the border because this right was not envisioned by Rule 57 mentioned above. So this individual, and is the case communicated to the ECHR, this person was not draftable because they were convicted criminals. They served their sentence, their term, but they couldn't cross the border anyway. And it was the first judgment taken within the first months of the large-scale invasion. And the public interest and the scale of the threat prevailed. So if you could be winding up, okay? Right, thank you. The Supreme Court has opened proceedings based on the station application. It was the repetitive denial of border crossing. The individual applied to the Cassation Court, and now This cassation application has started the proceedings, and the court is now considering whether the derogation procedure should be invoked. So I think that this case will be communicated or referred to the Grand Chamber. Thank you very much, esteemed Justice. So it is still an open question, but I think that ECHR can formulate its position. We understand that it is extremely difficult and challenging for the Supreme Court to consider and resolve such cases, but it will be even more challenges if we get ECHR judgments and the martial law would be still in place. It might even make this issue more heating and more challenging. We understand that it would be a totally new practice for the ECHR as it is for us, and then Ukraine will kick off the consideration of a new legal doctrine. But I think that the judgment of the court should also be mindful of the overall justice in a country at war. It can't be so that some individuals have only rights, whereas others have obligations alone. That's a very reasonable argument. But the balance of interests and reasoning is a key, not only to this category of cases, but everywhere where subsidiarity steps in, whereby the arguments and proportionality should be of key relevance. And I give the floor to Tamara Dudash. She's an associate professor of the Department of Theory and Philosophy of Law, Ivan Franko National University of Lviv. And she'll be speaking about the quality of arguments.
Але я щось її поки не бачу. Якщо вона з'явиться, то
I don't see it on the screen.
субсидіарності він зумовлює, зокрема, те, що всі аргументи національних судів мають бути викладені належним чином, щоб продемонструвати, що суди почули сторін, і щоб рішення судів були переконливими для суспільства. І в межах своєї доповіді я би хотіла розпочати з питання, як має виглядати імплементація. Наступний слайд, будь ласка. Конвенції у судових рішеннях. Ну, і тут очевидно, що вона має виглядати отак, як я сказала спочатку. Доладна, якісна, зрозуміло, що хотіли. Як вона виглядає? Тут я покликаюся на свої
I refer to my observations of myself, of my students. Very often, they quote one of the judgments, quotation from this judgment, not an argument. What could be done to improve argumentation from Caselaw European Court, to build them based on a certain sample that we can see what is the situation, what is the conclusion. Because my time is limited, I will comment briefly. My next two slides, they are citations from opinion of Consultative Council European Judges number 20 on roles of judges in ensuring uniformity of application of the law. Maybe you know it, but important is that we all understand
Далі,
it,
якщо
that
по-різному
if we use
застосовують одну і ту ж
case of European
презумпцію, це створює
court
невизначеність, це
as
підриває довіру
source
до
of law,
суду.
but if you don't
І
use it
якщо
uniformly, it
застосовують
undermines
іншу
trust of the
порівняно з
court.
попередньою практику тлумачення
If you
конвенції, то
use
це
different
відхід від
interpretation,
усталеної судової
different
практики, ну, принаймні так нам
interpretation of the case of
Наступний
European
слайд,
court,
будь ласка.
in that case you step away from
І
the practice.
тут також варто
Here,
звернути увагу
one should pay
на те,
attention
що
to the following things.
що буде свавільним виглядати судове рішення, якщо будь-який аргумент не прописаний
Decision will look
належним чином.
arbitrary if a certain argument is not prescribed
І
properly.
це, як на мене, ну такі вихідні пункти, які вже у нас
These are
звучали
the
щодо того,
basic
що
things that have already been mentioned.
і тут треба
Arguments from case law of European Court must be relevant, and we must agree between ourselves what is relevant, and consultative counsel speaks about principal circumstances. Maybe courts will speak better on that, how to use it better. And the last but not least, how the consultative counsel European courts say it can undermine Article 6 and cause violation. Taking into account
на що я звернула увагу, ми прочитали.
Benchmarks that I mentioned,
Я можу висновити про те, що правові позиції
I can say that legal stance of European Court of Human Rights used as arguments must be 100% correct by form and by content. On elements of quotation,
тому що там часто немає всіх обов'язкових елементів.
you must prescribe it, not just paste copy it. There are situations when European courts said one thing, national courts say differently, although it's not a civil aspect. Necheparik and Yopta versus Ukraine, it's an example that different things were used, not what the European Court wrote, both the form and the content should be proper. And court judgment is not just a citation. Argument is a statement that consists mandatory elements. The basis, conclusion, they should be reflected.
Там має це бути показано. Тобто оця релевантність буде забезпечена тим, що має в самому аргументі бути показана подібність чи доречність.
The argument itself must demonstrate whether this case is similar or analogous. Let it be one sentence, but that should be written. This is a question. I don't have answer to it. Can you use case law of European Court with relevant changes, mutatis mutandis? Probably yes. If we don't do it, that relevance will be put under doubt. In any case, this is my preliminary answer. It must be well grounded. The difference that exists between the decision is such that allows to use a certain legal stance. Next slide.
Що таке якісний аргумент з практики ЄСПЛ?
What is a quality argument from case law of European Court? When it becomes an element of court decision as the basic or additional, not just declarative or excessive. A judge must understand clearly whether he or she supports the legal position that comes from national law, then it is additional. When there is a gap, and you should use the principle in the court practice, then it is the basic one. Then it takes a different place, has a different importance, and should be prescribed differently. Logic of statement, its legal perfection. I will not speak much on that. The formats used you most know, it's clear conclusion. I have not invented the Ukrainian translation for that. The fact should be relevant, and that requires CRIAC, when there is also explanation of legal position of European Court in addition to that. And last but not least, at the Law Department of Lviv University, for some 4 years, we conduct analysis of arguments of case law of European Court in different courts of Ukraine, in different groups of cases, on the issues that are criteria of assessment. There were different groups of cases. Show my next slide. I will show you the results in the form of diagrams. The most interesting explanation is behind our backs, the answer to the question about criteria. These are the cases on establishing parenthood in decision of appeal court. Number of decisions based on which criteria we analyze them, and then students are explaining, defending, or arguing. We have interesting format of work with the students. Here I want to emphasize once again, proper implementation means implementation through quality argument. Maybe my topic is quite general, but I thank you all for your attention. Maybe your topic is general, but it looks like it is key things. You may know very many standards, you can read a lot of judgments of European Court, but if you just imitate application, it doesn't matter how much we know. Thank you very much for being brief. That just means to real be, not to imitate. And then we come to next presentation, Margarita Sokorenko. There is no need to say who Marina Sokorenko is. She is agent of Ukraine before the European Court of Human Rights. And she knows much about relevant problems that we have now, that we had in the past, and we probably will have in the future. Margarita, I invite you to speak. You will speak about problems of return of the children to the state of habitual residence. Thank you. First of all, I want to welcome all our participants of the 12th International Forum on case of European Court. And on behalf of the Ministry of Justice, to thank organizers for this forum, to thank Council of Europe Office, OSCE, Supreme Court, National School of Judges, and I'm pleased to say my native university, Franko University from Lviv. We have used all time for this session. I will come to the point. The issue of greatest relevance now, return of the children to the country of habitual residence and contact arrest. Ukraine is a party to Convention of Child Rights as well as other international agreements, and enforcement of judgments of European Court pertaining to this issue is also an important step of fulfilling commitments not only of European Convention, but commitments based on other international agreements that we have ratified. European Court of Human Rights is reviewing issues that are connected with return of children to the state of habitual residence, mainly based on Article 8, right to respect to private and family life. And when we speak about this group of cases, in most cases, European Court is studying how the state fulfills its positive obligation based on this article. Here I want to pay attention to the group of cases that already regarding Ukraine, MR and the R against Ukraine, pertaining to the violation by Ukraine of Article 8 of Convention, because the state authorities didn't abide by the commitments of prompt proceeding, of finalization of proceeding promptly, non-enforcement of judgment, or very long enforcement of the judgment. That is connection with the Hague Convention on Civil and Legal Convention on Abduction of Children. This group of cases combined 3 decisions. One was adopted in 2018, but when we compare it with other group of cases that are systemic, structural problems, quite new group, but conclusions made by European Court in this group of cases are of systemic and complex nature. When considering this group of cases, European Court formulated number of principles used when similar applications are being reviewed. European Court developed a position that when considering how state fulfill positive obligation based on Article 8, first of all, they look how state authorities fulfill the duty to take all measures for unification of parents with children. Emphasis was made that this commitment is not mandatory. Unification of parents with children sometimes cannot be urgent. It requires certain preparatory actions, but the nature of these things required certain behavior from the parents. And European Court makes an emphasis for the state and for the parties. Important component in such cases is understanding and cooperation of all stakeholders.
In addition, the European Court established that when challenges or difficulties arise, for example, one of the parents with whom the child resides, to allow the other parent to contact the child, then the competent authority should be entitled to use sanctions. And the European Court believes that children-related cases are very sensitive, but when there is the abuse of possession by one of their parents, then such sanctions should be applied. So the European Court also defines whether the national authorities have taken all necessary measures to ensure that the court decisions are enforced. And the a time factor is important. The European Court looks at whether those measures were taken timely, since in this category of cases, the time can have some irreversible impact on the relations between the child and the parent that is alienated from the child. So the European Court also states that when such cases are considered, the best interests of the child should be taken into account according to the Hague Convention. So now MR versus Ukraine, the European Court stating the violation on the part of the Ukrainian state says that the violations were related to the lack of legislative administrative mechanisms, the limited powers of public enforcement officers, and the lack of engagement of the experts from the service in the minor affairs. There's another case, Schwetz versus Ukraine, and there's a group of cases comprising 7 such cases, and it is also about the enforcement of the national court decisions on guardianship and access to children. And the conclusions here are similar to the previous group of cases. Given this large-scale of violations, the ECHR would be monitoring very closely the enforcement of such judgments, and in addition to the general measures related to the legislative framework, attention should be paid to individual measures or redress measures related to the return of the child or providing access or guardianship over the child. And here we pose to the challenges of today, the large-scale invasion that creates additional problems for the application of individual measures. I will give you just several examples of challenges that we face in enforcing such decisions. Bodnar versus Ukraine, for example, as matters stand, the national authorities cannot monitor the enforcement of this decision since the territory of the application is very close to the zone of active hostilities. So in the case Pleshkova and Pleshkova versus Ukraine, fairly recent judgment in this case has been taken. The indebted person is in the temporarily occupied territory. The house was destroyed and her whereabouts are not known, so she is wanted. And there's also positive enforcement in the case of Dubas versus Ukraine. After the large-scale invasion, the a respondent left the territory of Ukraine, so the National Court ruled to change the way the court decision should be enforced. Now the father is in communication with the child online. And this case is also, this group of cases is also being monitored. The Committee of Ministers has analyzed how Ukrainian public authorities enforce these judgments, and they positively noted the enforcement of the judgment in Dubas versus Ukraine case, and they encourage public authorities to take all possible measures to establish the whereabouts of all children in question and ensure that they have relations with the parents they do not reside together with. And since there is an issue with the legislation and limited powers of public authorities in this part, so over the last 2 years, the Ministry of Justice developed, together with some of the members of parliament, a number of bills to improve the provisions about the enforcement of court decisions related to children and the engagement of the guardianship bodies in the enforcement of such decisions and enhancing measures to ensure that the Hague Convention provisions are abided by. So since this group is smaller compared to other groups of cases versus Ukraine, we see that the reasoning of courts is very important when these cases are considered at the national level, and certain amendments should be introduced in the legislation. Thank you very much. I did my best to keep within the time limits. Thank you. Still, we are going beyond the time frame, but still, I will give the floor to our online speaker. And we will now give the floor to the person who assesses it on the part of the Council of Europe and comments on the implementation of the court judgments at the national level. Pavlo Pushkar, are you with us? Good afternoon, I am. Can you be speaking up, please? because we cannot see you, nor can we hear you loud and clear. Okay. Shall we wait then? Can you hear me now? Yeah, we still have certain technical issues with hearing and seeing you. Can you hear me now? But we can't see you, Pablo. Can you talk to us, please? 1, 2, 3, 4, I'm talking to you.
Вас чутно тільки в навушниках поки що.
We can only hear you through the headsets, but I think we can address this issue. Can we see Pablo on the screen? Okay. Now we can see you. Great. But we still can hear you only in headsets, but that's okay, isn't it?
Так, а тепер спробуйте з нами поговорити.
Now, can you talk to us again? 1, 2, 3, 4. Can you hear us? Me now? No, we can't, I'm afraid. What about this? Wait, can you hear me now?
Да, у нас є момент в тому, що ми чуємо вас лише в навушниках.
We can only hear you through the headsets. Bear with us for another 10 seconds, will you?
Скажіть, будь ласка, а у всіх є навушники?
Has everyone got headsets? If this is the case, we can please raise your hands, those who haven't got them. Too many.
Поговоріть з нами, Павло.
Pablo, can you keep talking? I understand my presentation should have been over by this time. Right.
Але у нас є пропозиція її розпочати.
Yeah, but we suggest that you start it right now, okay? Yeah, how much time have I got? Now we can hear you and we can see you.
Давайте спробуємо в 17 хвилин.
So if you could keep within 17 minutes, okay? Yeah, I'll try. Thank you very much for the invitation to participate in this wonderful forum. Unfortunately, I couldn't come to Ukraine. Several things that I would like to raise right now about the situation with enforcement of the ECHR about Ukraine and how we respond to this situation. I can speak about it for a long time, but I would want us to consider how we can change our attitude to the enforcement of the ECHR judgments and speak about them not about relevant and legally important, significant and binding legal instrument of the international nature that established certain obligations based on Article 46 of the Convention. But I would also like to speak about the judgments of the European Court of Human Rights as legal mechanisms, certain functional mechanisms that enable us to upgrade, to improve the legal system of Ukraine and take measures gearing towards European integration of Ukraine. So I would like to raise several issues relating to the enforcement of the ECHR judgments about Ukraine. So what happened in 2024? The Committee of Ministers managed to consider a number of key cases with the nexus to Ukraine. These are the so-called Maidan cases, Chernov and others versus Ukraine, and Alexander Alexander Volkov versus Ukraine about the independence of the judiciary in March this year. And in 2024, the Committee of Ministers, through monitoring the enforcement of the ECHR judgment, considered the group of Ignatov versus Ukraine, Majitsky and Sugachov about the detention conditions, and Malitsky and Yeremenko on the right to protection in criminal proceedings. And quite recently, and I saw that a certain discussion took place in the social media about it. The Committee of Ministers considered the group of cases related to the rights of the child that we've discussed so far. So there are certain achievements that we can discuss here. First of all, the transfer from close monitoring to standard monitoring in Baletsky and Yeremenko group of cases in June 2024 due to changes in the legislative framework, significant changes to that, and the practical implementation of this legislation. Another achievement worth mentioning is on the closure of monitoring in China versus Ukraine. It was about the alleged gap in criminal code of procedure without detention, without court decision. That is the period between the closure of investigation and the beginning of the court proceedings at 2469 or 99, sorry, bill. In addition, I would like to mention certain developments when it comes to other categories of cases that are still problematic. And I would like to refer you to the structural and systemic problem of failure to enforce in the case of Jovner and Ivanov and others. And it is about the undermining of the essence of the rule of law in Ukraine. Now, we understand that in the context of the war, the country has limited funding for the enforcement of the judgments of ECHR. But some of the issues go beyond the context of war and have been accumulating over a long period of time since 2001. Another issue has been defined when it comes to the structural independence of the judiciary, and it's the Alexander Volkov group of cases.
If there will be time today, probably later I will have possibility to speak about execution of judgment of Volkov group cases in other section. Formation of service of inspectors, practice of disciplinary liability, and legal certainty in disciplinary liability of judges, definition of reasons, limitation terms, etc. Third challenge was mentioned: excessive length of court proceedings that is connected with resources of judicial system. I would like to differentiate group of cases Kavirzin and Thanasiev relating to the problem on inefficient investigation of torture and ill treatment that remain unresolved for quite a lot of time. Too soft judgment of court against law enforcement officers. Non-implementation, zero tolerance to torture that is tolerated in Ukraine at highest level. One should remember legal change to Article 127 regarding cancellation of terms regarding cases of torture. Fedorchenko and Vazenko, non-investigation of cases of racial and religious hatred, investigation of Mandan cases that are not finalized and are still under monitoring of Committee of Ministers, and cases of death incurred by private persons. There are many standard decisions made by European Committee on Human Rights. The problem of fighting discrimination in Ukraine is very relevant. Now we are preparing to review case Maimulakhin and Makhiv in Committee of Ministers in December this year. The need to adopt draft laws that are already elaborated regarding possibility of concluding same-sex partnership. Draft law 9103 that will allow at the legislative level single-sex partners to register their relations and get personal property rights. That is especially important in condition of war. One can provide other examples, which cases are under monitoring or Committee of Ministers. You can mention quite unpopular problem in the context of monitoring implementation of commitments of Ukraine to Council of Europe for many years. Resolving these problems is quite necessary even in condition of war. And the work on improving efficiency of investigation will help to investigate war crimes, use methodology of investigation offered by judgment of European Court of Human Rights and practice of the Committee of Ministers of Council of Europe. In conclusion, before I come to the end of my presentation, I want to say that one of the most important steps to enhance requirements to execute judgments of European Court. What is the key element of convention? As was mentioned, but a newly appointed General Secretary of Council of Europe, Lambertse, one should come to the problem of revision of the norms, quite outdated norms on enforcement of judgment and the Application Convention that was adopted in 2006. At that time, it was quite a positive step. That law facilitated direct use of case law of European Court of Human Rights by national courts, but it has narrowed and formalized enforced execution of judgment. And now this law cannot cope with systemic and structural problems, with repeated cases and problems defined in Ivanov and Burmach group of cases. Enforcement of judgment. It's been discussed for quite a long. Adoption of the law in new version is quite needed, and this forum recommendation should support this idea. I hope the colleague will support this idea during discussion of the forum. Thanks to our opinion, adoption of amendments to the law on execution of judgment of European Court and consideration of other draft laws will help Parliament to make a breakthrough to enhance protection of human rights and prevent further violations of conventions that bring not only legal but external political dividends regarding accession to the European Union. In conclusion, I want to emphasize first on the duty of Ukraine to fulfill judgment of European Court and to remove violations established in situation of war and limited resources. It's difficult to resolve number of complicated problems. It seems that this is mission impossible, but still, measures used in the cases that I have mentioned above prove that considerable progress is possible. I want to thank Margarita Sakarenko and Ministry of Justice for the work that they are doing. In many cases, it's not the issue of resources, but existence of political will for proper implementation of convention. Measures to be taken to execute judgment of European Court must be comprehensive and sustainable development improvement of legal system of Ukraine. Council of Europe now is ready to support Ukraine in execution of judgment of European courts through permanent dialogue and through cooperation projects, including participation in this forum. Thank you for your attention.
Дякую.
Thank you.
Дякую, до речі, за надихаючий такий
I
меседж.
thank you for inspiring message that development is not only needed, but it is possible even in these conditions, and war cannot justify absence of some action, but rather be an impulse. We have no time for questions and answers. Therefore, we immediately invite you for coffee and ask you at 1:15, come back. At 1:15, we shall start next session, a criminal law. Thank you very much. And you can applaud to our speakers and ask your questions during coffee break.
Колеги, ми будемо розпочинати. Будь ласка, проходьте до залу.
Dear colleagues, we are resuming our work. Can I invite you to join us in this hall?
Прохання до шановних спікерів зайняти місця на сцені
Request
і
to
до
the speakers to join us here on the stage. We are resuming our work.
Я коли просто ловлять, тому я цей відволікаюся.
Шановні учасники, ми будемо продовжувати. Будь ласка, підходьте. Займайте свої місця.
Dear participants, could you please take your seats? We would be resuming our work.
Остання, крайня, як вірно сказати, сесія перед обідом. В мене є інформація, де він буде відбуватись, але я не скажу її, допоки
This is the last session before we break for lunch. And I even know where lunch is to take place, but I won't share this valuable information with you unless you are all seated. Now we've got our speakers on the stage, and so we are continuing. I am Alisa Pitakhova. I am manager of the project of the Council of Europe Fostering Human Rights in the Criminal Justice System in Ukraine. And I've got the honor of moderating this discussion dedicated to achievements and challenges of the implementation of the European Convention on Human Rights in Ukraine, criminal aspects. The European Convention has been in place for over 70 years, so it guides the countries of the Council of Europe, including Ukraine, particularly now that we live under the martial law. We have certain criminal proceedings related to war crimes, and we should remember that every such proceeding should be in line with the conventional standards. Now, Europe and the whole world are looking at us very closely, and the way we are to proceed with the consideration of the cases like this, whether we are in line with the Council of Europe standards, are all very topical issues. This session will be divided into two parts. The first one would be about prosecution for crimes against international law and issues of non-retroactivity of criminal law under Article 7 of the ECHR. And I will be giving the floor here to Mr. Gnatovsky and Mrzyanovska. And the next part is about the pretrial detention and challenges that Ukraine faces in this area. So, as part of the moderation, I would like to remind the speakers about the time limits. When we come very close to the end of your time, I will remind you that you've got 1 minute to finish. Without any further ado, I will give the floor to Mykola Gnatovsky, Judge of the European Court of Human Rights for Ukraine. He is an international law expert. Thank you very much for being with us today.
Ще раз дякую вже мікрофон. Пані Алісо, дуже приємно
вас бачити. Thank you very much for the microphone. It is my great pleasure to be with you. Thank you for inviting me to be part of the 12th International Forum and in this particular discussion in such a wonderful company. Alexandra, Margarita, Olesya,
It is great pleasure and honor to me for me to be amongst you. So this is the panel dedicated to criminal law aspects and the question of prosecuting for crimes against international law
має свій правозахисний аспект не лише з точки
have
зору
got their legal aspect not only in the context of international obligations and commitments to do everything possible to bring the offenders to justice, and this is part of the international law, in particular provisions of the International Law of Human Rights and the European Convention on Human Rights, amongst other things. It is also part of international humanitarian law, criminal international law, and it is evident that the state is obligated, it's bound to do so. It's not about politics. It's not about goodwill to respond, say, to the aggression against our state through the criminal law response measures. It is our obligations. It's part of our international commitments. On the other hand, there's an aspect related to the rights of persons that are suspected of those crimes, and their procedural rights and safeguards should also be observed. And it's a non-banal task because standards of international law have been developed with a view to the ordinary crimes, the crimes envisioned by the national criminal law of the member states, and it shouldn't always be the crime against international law or international law order. And finding a fine balance is a very challenging task. But it isn't extremely challenging. It is quite addressable, I would say. Now, we have to ensure that Article 7 of the ECHR has been abided by. That is, not only the conventional commitments are respected and honored, but also the general principles of criminal law, legal principles that are inherent in any legal system, be it national or international. It's a non sine lega. That's the principle of the legality and lawfulness of criminal prosecution and the broader meaning of the term. When I said that these tasks are not banal, I didn't mean to say that it's something that the ECHR does not apply to. On the contrary, Article 7 is so worded that it underscores its total applicability to crimes against international law. Item 1 of Article 7 mentions international law, and the requirement of legality is ensured by the fact that a certain act or mission should constitute a criminal offense under national or international law. Item 2 of Article 7 reads that
відповідатиме вимогам
сьомої статті, it should not prejudice the trial and punishment of any person for any act or omission which, at the time when it was committed, was criminal according to the general principles of law recognized by civilized nations. In this context, one should note that there's a typical error in interpreting item 2 of Article 7. And the error is that point 2 exemplifies an exclusion from or exception from item 2. That is, when there were no such provisions in national or international law, you could have sought for such grounds in general principles of the law. But that's not so. Item 2 of Article 7 just develops the requirements of Item 1, nor does it object to the first item. It seems counterintuitive, but it is the consistent position of the Grand Chamber of the European Court for Human Rights, particularly in the case Vasiliauskas versus Lithuania and the case about crimes committed in the context of the war in the former Yugoslavia, Faktor Judjanovic versus Bosnia and Herzegovina. So this is a notable moment. And if we translate it into practice, we need to ensure that item 1 has been followed. So there is no practical utility from item 2 because the standard is laid in item 1. So, but there might be a challenge. It could seem that there is a challenge that Ukraine is trying to face right now in the context of the proposal, or rather the fact of the ratification of Rome Statute in Ukraine. And the principal guarantees have been submitted to the depository, and on the 1st of January 2025, Ukraine will be the 125th member of the Rome Statute. And sometimes people speak about the quandary or about a conundrum of whether Article 58 of the Constitution of Ukraine that reflects the provision enshrined in Article 7 of the ECHR. So whether this article allows to apply legislation retroactively, particularly when it comes to war crimes. And this challenge seems to be most acute when it comes to crimes against humanity that Ukrainian criminal law did not know of. So as far as I understand, this is the matter of interpreting the Constitution of Ukraine. I'm in no position to provide any final answer to it. Ukrainian courts are in such position, but it would be logical to predict that Article 58 should not be considered such that established substantive requirements different from those of Article 7 of the Convention. It's my just general hypothesis, but it's up to the colleagues in Ukraine to give the definitive answer to this question. From the perspective of the ECHR, the questions can arise from non-observance of Article 7 if there's ground to believe that an individual was convicted based on the law, which was not predictable at the moment of the commission of the criminal acts.
If there was a problem with application of relevant punishment, this penalty was not provided for at that moment of time. What questions arise in case when national legislature decides to define crimes broader than they are defined in the international law? there is a problem. It is quite debatable. Here, European Court of Human Rights cannot offer better basis for consideration than Grand Chamber decision in the case of Vasiliauska's case and Drelinskas versus Lithuania. This is a judgment of chamber, but it specifies certain things taking into account principle of subsidiarity that we discussed in the morning. That takes a note how Supreme Court of Lithuania resolved it. In Vasiliauska's case, Grand Chamber with small advantage of most found violation of Article 7. In the other case, conclusion of the court was opposite. They talk about the definition of crime of genocide in Lithuanian legislation, which is broader than in articles of Rome Statute and in international law. Lithuanian definition is broader. They add the groups against whom, political groups against whom crimes are committed, who are not included in the convention as protected groups. Coming back to the thing, how to decide cases based on Article 7. There are not many of them. That Council of Europe is working very actively, trying to make our best database of knowledge about court, make it accessible to all lawyers and to all judges. In this database, you can find Article 7, and apart from general guidelines, there is a new document prepared in the end of August of this year, where the issue of international crimes and compliance with Article 7 on compliance is discussed. Up to now, it is in English and French only, but Supreme Court shows such progress with translation. Probably it should be translated in Ukrainian. Thank you. Later, I will take part in the discussion. Mykola, thank you very much. Your speech, as always, is about inspiration, about desire to look for new possibilities for development of the system. Alexandra Yanovska, Judge of Supreme Court, Doctor of Law, Professor at Kiev Taras Shevchenko University, and she is also an expert of Council of Europe. Thank you, Alisa. I'm very glad to be here with you. Here for me, it's a great honor to sit in this panel near such well-known experts, especially in the sphere of humanitarian law. I remember your presentation, Mykola, was a discovery for me. They opened a new world for me. Thank you for the opportunity to be at this forum, to speak here. I want to note especially that it's very pleasant for me to see young people, students, because future belongs to you. As regards the topics that started to be discussed so well by Sternatowski, I was considering this topic for quite a long time. Probably, as regards retroactivity of application of criminal law and take into criminal liability for war crimes, for crimes against humanity, it will be the national court who will put the final point. At Supreme Court, I cannot give final answers. but this final full stops later will be double-checked by European Court of Human Rights, among others. What I will be talking about now, these are my personal deliberations. Probably you will agree that the issue of taking to liability for crimes against humanity for Ukraine, for Ukrainians, is the issue of justice, of fairness. Very often I heard the opinion, does it matter based on which article a person will be taken to criminal liability? Important is that person is taken to liability and is punished. But idea is not in that. There should be justice and fairness. Those who are guilty of committing atrocious crimes, some of them even don't have status of limitations. That is as regards general approach. Being a specialist in procedure, I think that important is how to prove these cases. One thing is to find evidence and proof in case of conventional crime, if we can call it like that, rape. And when we consider war crimes, crimes against humanity that are committed in condition of large-scale systemic actions aimed against population. I think it is not an ordinary task. I agree fully. To make person liable doesn't matter based on which article. Is it important to abide by the requirements of Article 7 and requirements of our domestic legislation? I saw a number of problems here that at first sight are difficult to resolve. Recently in our criminal code, we got changes as regards introduction of new norm. Article 442 that is a crime against humanity. That is implementation of Rome Statute. But how to take a person to liability for crimes that had been committed before? While we have Article 8 and Article 7 Convention, I think, first of all, I see two options here. First of all, we must not forget that our legislation, even previously, our criminal law was not so bad. Article 438, which remained now, it was called violation and rules and habits of war. Now it's called war crimes. Apart from list of quite concrete characteristics of crime, it was referring us to the violation of rule or habits of war provided for by international law, which is ratified and is used in Ukraine. Verkhovna Rada ratified them and now they are mandatory for use in Ukraine. Esteemed Mykola Hnatovsky spoke about that a lot. We have the Hague Convention, the Geneva Convention. They provide us broad spectrum, broad list and definitions. What is war crime? What is violation of rules and habits of war? And nothing prevented us from doing it before, and nothing prevents us from doing it now, to use this norm of legislation without getting deep into application of Article 7 of European Convention. The other option is probably the one that Mykola mentioned, direct reference to international agreements directly when national legislation didn't contain any norms that define specific criminal offenses, but these are the norms defined by international agreements. Certain judgments of European courts have been mentioned. I will mention other case, Konda against Latvia. Just this approach was used there. Provisions of international agreements existed long before the tragic events that are happening in Ukraine for last 10 years, especially during last 3 years when they are of very large scale. We must not have any doubt at all that direct reference to international agreements, to Geneva Conventions, Hague Conventions, that would be violation of principle of retroactivity. Our Constitution says international legislation which has been ratified, it is part of our legislation. Criminal code is based on Constitution and international agreement, and its existing case law of European Court give us very clear picture. If we want to get justice and fairness, if we want to take to real liability all the offenders, if we put that as a main goal, rather than attempts to use legal remedies not to punish the countries and particularly guilty individuals that commit atrocious crimes in the territory of Ukraine. And not only, I think for sure we can use a direct reference to international agreements. What is dangerous? Dangerous is reference to Part 2 of Article 7, that there are general rules recognized by civilized nations, and that is enough. We have already certain case law. So-called Department of Law of Office of Prosecutor General was developing approaches how to use contextual element to prescribe indictment, take into account the circumstances of a particular crime in conditions of war. I think here we must also develop approaches, how formulation of this vision, incrimination of crime, not just making reference to general principle of law, but to concrete provision of international law.
Then we would use Article 338, but in other cases we would be using the new Article 442 prim. I will stop here. Should you have any questions, I would be glad to answer them, and we will hark back to this idea. Thank you, Alexandra. Now that this demand for justice is so insistent, we are doing all we can to bring the offenders to justice, and all of that should be in line with the European Convention, because it is also part of our Euro integration activities. Our next part of the discussion would be dedicated to excessive pretrial detention, and it is a systemic issue that has been stated in many decisions of the Committee of Ministers of the Council of Europe. And I will give the floor to Ms. Margarita Sokorenko, agent of Ukraine before the European Court of Human Rights. She is in charge of representing Ukraine with the European Court of Human Rights and for the monitoring of the execution of the judgments of the court. Thank you very much. It's great to be here with you again and to catch up after the incredible speakers, Mr. Gnitovsky and Mrzyanovska. These issues will indeed be reflected in our relations with the European Court, and these moments are very important to me as an international lawyer. But I will be speaking about detention. It's not a new topic for the Ukrainian state. I could even say that it has been discussed for quite a while, but it doesn't make it less topical. And we will be speaking about excessive pretrial detention and whether this long pretrial detention meets requirements of Article 5 on the Convention. Article 5 provides for the following. Everyone has the right to liberty and security. No one shall be deprived of his liberty save in the following cases and in accordance with the procedure prescribed by law. But there are certain exemptions, 6 types of grounds that are worded in item 1 of this article. And this is a finite list. Right? At the same time, detention is one of the most widespread ways of limiting liberty, and it is essential that this measure is used in full compliance with item 1 of Article 5 of the Convention. And in order to define whether the person was deprived of liberty lawfully, the start point should be the specific situation of a person, and we have to take into account a number of criteria such as the type of the crime, trend, and the case law of the European Court testifies that the question whether the person was deprived of liberty according to Article 5 of the Convention is considered in each case separately within the context of each and conditions of each case. And I would like to draw your attention to 2 judgments of September this year. They were made on the same day, and they were all about Article 5, lengthy detention, and they have reference to our country. The first judgment is the ruling on inadmissibility, where applicants complained that item 3 of the 5th article was violated, and they stated that the decisions of the national courts did not provide sufficient grounds for this lengthy period of detention. And upon studying all of the circumstances of the case, the judges of the European Court decided that the courts provided the grounds for the initial detention and for the extension of the period of detention. The European Court stated that there was the well-grounded suspicion of the commission of the crime and the risk of the applicants fleeing from justice were fully described. So the detention of the applicants was also grounded on very good reasoning. At the same time, on that very day, the European Court judgment in Syriza versus Ukraine, where they stated the violation of item 3 of Article 5. The applicants also complained about the lengthy period of detention, pre-trial detention, and the European Court analyzed the materials of the case and the application itself, and they found the violation given that the national
courts. Well, they considered this complaint reiterated the ground that ceased to be reasonable, and the assessment of the situation of the applicants about the reduced risk of a repetitive commission of the crime or absconsion. And they also said that the courts did not consider alternative measures of restraint. And I would like to underscore that in majority of judgments where the ECHR finds violation, these grounds are given as drawbacks of the national court's decisions on extending the detention period. So these are the two cases. Two judgments were recently adopted, and they show two different contexts, whereby in one case it wasn't admitted, and in the second case there were insufficient grounds. The second judgment shows that we do have serious drawbacks in court practices when we speak about the application of this measure of restraint. And again, these two judgments point to what we discussed before, that the provision of relevant and sufficient grounds for detention are a prerequisite for the assessment of the measure taken by the state as just, as fair, and as lawful. So it is essential that all of the circumstances of the case should be taken into account, and it is also important to avoid the abuse of Article 5. So this group of cases have stayed with Ukraine for some time, and there are several negative decisions or judgments against Ukraine, and this issue is systemic and structural in nature, and it has been closely monitored by the Committee of Ministers. And Pavlo Pushkar referred to this group of cases, Chaniv Ignatov versus Ukraine. This one is Ignatov versus Ukraine, and it is one of the most numerous categories of cases against Ukraine and negative judgments against Ukraine. And if whereas some time ago, the legislative amendments were necessary and the practices were also to be changed. The legislative amendments have taken place. 2699 referred to by Pavlo Pushkar about the pre-trial detention and the gap between the end of investigation and the beginning of the court proceedings. So large attention is being attached to it by judicial practices. And to the end, I would also like to comment on one important element that becomes evident today and that needs to be taken into account by the national courts when it comes to pre-trial detention as a non-alternative measure of restraint. In view of amendments to item 6 of Article 706 of the Criminal Code of Ukraine, it was amended. According to the amendments during the martial law, individuals suspected of or charged with grave crimes like terrorism or a threat to the national security, only one measure of restraint can be applied, that is detention. And this novelty was introduced to improve security in the conditions of the martial law and responding to the new types of threats. You can speak about pros and cons about the extent to which the response to the heightened levels of threat is adequate, but it can be associated with certain risks. For example, potential abuse and violation of human rights. And I think here we should be speaking about the rights of the suspects. And in this context, I would like to draw your attention
to the need to analyze our previous experience when we had similar a regulation back in 2014, 2015. That was Article 175, and the language was very similar. It was about grave offenses where there was no alternative to pretrial detention. And then there was a famous case, often referred to, Rubnik versus Ukraine, where the applicant complained about the violation of Item 3, Article 5 of the Convention on excessive pretrial detention. And the courts referred to this item. Upon considering this case, the European Court found no violation, since even though there was such a regulation, the national courts, while extending the detention period, continued to assess the existing risks, even though there was no alternative to detention as the measure of restraint. They considered whether there were risks related to release of the applicant from detention, and they provided sufficient grounds for the extension of this measure of restraint. So again, we can see from our own experience that it is important to provide high-quality reasoning to the decisions. And on the contrary, Alexandrovska versus Ukraine, the European Court found violation of Article 5 of the Convention because of Item 5 of Article 176, with referral to this norm without subsequent detailed analysis of the circumstances of the case. Why is it important to study all of the case circumstances and assess all of the associated risks quoted in Article 176? Because the communication to the European Court pertain to the new provision, Item 6, and the Office of the Agent of Ukraine before the European Court of Human Rights considers these cases. So when it comes to excessive pretrial detention, the rule stands that the measure of restraint should be well-founded, it should be constantly revised, and if with time the risks are mitigated or disappear, then the measure of restraint should also be revised in order to ensure this balance between public interest and the rights of individuals, in this case suspects. So I'll stop here. Thank you very much for your attention. Thank you, Margarita. Indeed, the issue is perennial, and hence the Committee of Ministers encourages Ukraine to improve its practice of applying pretrial detention, and the Criminal Code of Procedure or Code of Criminal Procedure should be properly used not only by judges but also by prosecutors. And I will give the floor to Olesya Tardnovna, head of the Prosecutors Training Center of Ukraine, a doctor of law, for her to comment on this topic from the perspective of the prosecution. Dear colleagues, dear friends, it's my great pleasure to be with you here with such wonderful panelists, many of whom are my personal friends. It is both responsible and pleasant. And I would like to thank the Armed Forces of Ukraine for this opportunity to meet with you offline to discuss these issues with no threat from above. Now, when it comes to our activities as the Prosecutors Training Center, we provide training services to the incumbent prosecutors and candidates to the prosecutorial positions. Then we discuss with them this measure of restraint as detention, and we also speak about them about the following. The fact that the state keeps in detention so many of its citizens cannot be put down to the gravity of crimes. It is more about the mindset. So indeed, legislation does not require that always criminals should be kept in detention in the pre-trial period, but the change of mindset requires effort, requires time, and professional training, of course. I would like to draw your attention to a number of aspects that we take into account when we train prosecutors, be it incumbent or aspiring prosecutors to be. It is a systemic and a structural issue, of course. The case of Ignatov, Chanev, Karchenko, all of the cases that have not been well substantiated in the use of detention.
There is also responsibility of prosecutor who is asking for that. The fact that extension of pre-trial detention is also an important aspect. Conception of the views of the court and prosecutor should be changed. Other aspect, the use of bail as an alternative to pretrial detention. I have interesting statistics. It does not pertain to war crimes because there is no alternative there, but it pertains to corruption crimes. What statistic shows? The biggest bails asked by anti-corruption court, 523 million hryvnias head of the property fund, 222 million to Deputy Minister of Defense, who was buying food for the army at highest prices, 272.5 million hryvnias for ex-member of parliament suspected in making loss to the state, 927 million, 229 million for ex-chairman of Naftogaz, who has got the bonus of the. I can continue this list of bails defined for suspects. Here one should pay attention to the Istomina versus Ukraine case, because the state asking such a bail does not mean the return of the money to the state budget, but rather to prevent fleeing of a suspect. The complaint didn't give possibility to put such a bail in the mentioned case. That pertains less to the war. It pertains rather to our general legal system. We draw attention to prosecutors. Please make your request to the court to be in conformity with amount that person is suspected of embezzling. And what Margarita spoke about, I want to add to what he said. There is a decision in Constitutional Court on that. If then Part 5 was not constitutional, as regards Part 6 was constitutional. The viewpoint of Constitutional Court was interesting. They said it's not so non-alternative. Pre-trial detention has alternatives. Constitutional Court believes, according to mentioned principles, when pre-trial detention is used at Part 6 of the mentioned article, there is a possibility to use bail as a softer measure. They refer to Part 4 of Article 183, which says that Part 3 said that court is obliged to review bail as an alternative, and Part 4 says, in case provided for in the law, crimes against national security, some crimes against public safety like terrorism. The court may not use bail. So Constitutional Court may conclusion they may use or may not use. That means that it's not without alternative. But in fact, courts and especially prosecutor's office read the norm of Part 6 of Article 126 directly without reference to rule of law. They read only this norm of the law that has only pretrial detention. But when talking about pretrial detention, in these cases, absence of alternative doesn't mean lack of motivation. It doesn't mean arbitrariness in decision-making of prosecutor office in particular. There is always a possibility to use or not to use this pretrial detention. And when the court makes decision to use it, same criteria, same risk provided for in Article 177 and 78 must be assessed. Sometimes emotionally it's difficult to make different decisions because you want to punish them all because of, but I want to support what Alexander said. That doesn't mean real justice and fairness. This human desire as citizens of the country that is suffering from armed aggression. We have this wish, but we must remain a democratic country that respects the rule of law. Ukraine remains a member and a part of European community, and we shall move in this direction. Thank you. That is all. Thank you, Lesia. I want to add from me myself, any development of criminal justice is not possible without education. And training center prosecutors is doing great job. We are always ready to support, help you, and continue moving together to implementation of convention and European integration. Yuri Pich will be the last speaker. He is assistant of criminal process of Department of Law of Lviv Franko University with his presentation. Evidence is proof in using pretrial detention. Practical challenges. Please, the floor is yours. First of all, I want to welcome esteemed audience and thank for the possibility to represent Lviv University in this discussion. And I want to thank previous speaker, Margarita and Olesa in particular, who laid a powerful basis for use of pretrial detention as exceptional means. And I come to issue of evidence and proof. Evidence and proof in context of conventional standards is quite delicate issue. European Court many times emphasized that the court tried to step aside from evidence and proof and gives it to the discretion of domestic court. But that brings us back again to the denominator, subsidiarity concept. And with this note, I could have concluded my presentation, but this doesn't allow us to believe that convention and case law of Strasbourg Court doesn't contain uniform standards of evidence and proof in this category of cases. I want to emphasize exceptional relevance of this topic. It pertains only to pretrial detention, which is an important violation of human rights in criminal proceeding. As of today, this issue is very topical in the context of practice of using these preventive measures by investigative judges. If we analyze statistics published by Supreme Court last year, more than 30,000 requests to use this pretrial measure were applied. 2/3 were satisfied by the court, and pretrial detention was applied. Next slide, please.
Відповідно, аналогічна ситуація десь передбачає
Similar situation includes a trend of extending pretrial detention lengths. Here, the percentage is even higher. To finalize the statistical data, I can refer to assessment of legality and well-foundedness of the decisions of courts by appeal court. Out of 5,000 decisions reviewed by appeal court, only 638 were squashed. That shows certain problems in the system of legislative regulation and in practice. Back in 2011, in Harchenko versus Ukraine case mentioned here, European Court emphasized systemic problems in implementation of conventional provisions of Article 5. And this is even more topical now. The question is reasonability of length of this pretrial detention, and that will be connected what court said regarding substantiation of this required term of pretrial detention. Court said that sometimes this argument are very abstract. They just state the need of pretrial detention for a certain period of time normally. They ask for maximum term, and second, well-foundedness of extension of this pretrial detention. I met cases when pretrial detention was extended several times. Only dates were changed by the court. It's a topical issue. Now, when Article 615 Part 2 was applied, prosecutor's office was allowed to use certain measures to extend pretrial detention. The question is, which standards are in convention regarding proof and evidence? I do not want you to read this slide, but I want to say that European Court is sharing certain aspects in evidence and proof that could be divided in two parts: the burden of proof and the concrete subject of proof.
Європейським судом з прав людини неодноразово наголошувалось на тому, що такий тягар не може бути покладений на особу.
This burden cannot be laid on the person against which this measure is being used. Otherwise, it would null and void Article 6 of the Convention. So in the court practices, it can be manifested through violations in two aspects. First of all, the courts have reasoned the need for the measure of restraint because the individual did not actually disprove the argument of the prosecutors. And in the case Moiseev versus Russia, whereby courts, when they decided on the measure of restraint, did not allow the person to realize their right to protection. Then one can assess this issue in the context of the subject of reasoning. What facts should be proven and what evidence is needed to prove a certain position. And in this context, when it comes to the subject matter of the proof, then we look at standards of convention in two contexts. First of all, how they are implemented by the law through the certain provisions of the Criminal Code of Procedure and in the judicial practices. So when it comes to Article 5 of the Convention, how they are implemented in the national law, I wouldn't comment on that since we don't have enough time, but I would rather comment on the subject matter of proof. So from the Article 5 guarantees, it ensues that it should be manifested in several things. First of all, it is well-grounded suspicion, and there's no need to explain what that means. And when we analyze the rulings by the investigating judges, it is difficult to find whatever in Nichiparuk versus Ukraine and Yonkalo versus Ukraine, and it will be the matter of reasoning. But again, the well-grounded suspicion should be substantiated by certain evidence. And given the spirit of the convention, one should speak about the following approaches to the substantiating of a suspicion. Here we can speak about the substantiation of a suspicion through the facts and circumstances that would corroborate the correctness of the criminal classification, because sometimes the classification could be heightened artificially in order to make sure that certain procedural instruments or tools are being used, as well as the most severe measures of restraint are applied. Unless you give the evidence that would substantiate the correctness of this qualification, and the entire set of evidence about the circumstances that would show that the criminal offense has taken place. And this well-grounded suspicion is the least standard of proof, and very often courts do not abide by this rule. And quite recently, there was a fairly high-profile case in Turkey or Turkey, where in the spring of 2024, there was a violation of Article 5 when it came to the illegal acts of a person in the context of their public statements that were qualified as terrorist activities. It was Yüksek versus Turkey. And if we continue speaking about the substantiation of the use of a certain measure of restraint, one should underscore that it is also a problem whether the extension should be given automatically to a certain measure of restraint, but I would not be commenting on that. That has already been mentioned. Now, the second aspect of the subject matter of proof when it comes to the substantiation of certain risks. Yuri, you've got only 2 minutes to go. Okay. Now, the facts and circumstances that should be established here and substantiated by evidence can be divided into two things. The evidence that would point to the availability of risks prospectively and retrospectively or retroactively. The prospective nature would be in that you have to prove that the risks are very well corroborated or substantiated that they can happen in the future. But the retrospectivity means that you should prove that their previous actions testify to the attempts to realize those risks. So the lack of evidence that would testify to this activity retroactively would not state that these risks will be of value in the future. And the very last issue relating to the subject matter of proof,
is
the one that the previous speakers have already spoken about, is the alternative. How do we prove that there is no alternative? It does not ensue from the convention directly from the case law of the ECHR. The courts did not even ask themselves about the availability of any less severe alternative. And to end, I would like to highlight one of the problems in the legislation since item 6 of Article 176 about no alternative to detention. It does speak about the availability of certain risk, but item 8 does not provide for any pointing to those risks, which means that the issues should be addressed properly. But the convention standards actually give us the grounds for a positive answer to this question. Thank you very much, Yuri. That would be the end of this session, even though the topic has not been exhausted. And I hope that next time we have a whole day to discuss criminal aspects of the implementation of the convention. Now we'll have lunch on the ice floor 7th for the British English speakers. And please be back at 3:10 or 3:15 at the latest. Thank you very much and enjoy your lunch.
Ви вже написали, ви ще його бронзу, а ми ще докази не бачили. Бачите, це ще було. Це коли перебування. Я пропоную, що більше записали на але які мають добровольці, мають поранення, мають забрати нагороди, знаки, характеристики. На 5 днів, а зазвичай більше і навіть раніше зараз це вже забуває. А він пішов, мав навіть знати, що мама а біля комп'ютера то кримінальне відповідальність. А якщо
Hello.
Mr. Dimitrov, this is the interpreter speaking. Good afternoon.
Great.
Uh,
Good afternoon.
yeah, we are starting at 3:15, 3:10 or 3:15 because they
Okay.
are a bit late. They went to lunch late and they start later. Do you have any talking points perhaps to share with us?
Well, I have sent them to Mamuka, but the fact is that they're just talking points, so you can look at them, but they will not be exactly what I'll be saying.
Yeah, nobody forwarded them to us, unfortunately.
Okay, so how can I forward them to you? Could you send me on?
If you go to the chat of the Zoom, I'll put down my email address, if that's okay. Thank you very much.
Let me see what is the chat.
The chat at the top of the panel.
Chat, here it is.
Right,
Okay.
yeah. And now I will find you there.
Okay, I'll give you my email address now. It is
Here's my address in the chat. Okay.
fine. So I'll pick it up now and try to.
Yes, if you just copy it and then paste it into your.
That's what I'll do. Yes.
Great. Thank you very
Right,
much. I'm looking forward.
compose,
Thank you.
And I will send you with no subject. Maybe.
Right. Yeah. Thanks a lot. Thank you.
I'll find them now. I have to find. Oh, I'm sorry. Just a moment. Okay. I have them on. Here we go. As a matter of fact, am I visible when I'm doing all these funny things or not?
You're visible in a smaller window of the screen, but when you start talking, you will be at the large screen and people will be able to see.
I'm visible while I'm looking for the text here. I mean, nothing.
No. Just it's only you.
I was joking.
In the window. Right. Thanks a lot. Thank you.
And now I send it. Okay.
Thank you.
Did you get it? Okay. So.
Not so fast. Yeah. Okay. We'll wait.
Okay, now launch meeting. So this is the way I should be back to you. Okay. Unfortunately, it doesn't react. Okay, it looks. Okay, now I'm inside. I'm closing the chat. And hopefully I'll be able to see you. The options. Side-by-side mode. And the only thing I can see here is myself. Okay. So Miss Inozentseva, I seem to have, or is this your name? Hello.
Давайте протестуємо. Hello? Do you hear us?
Hello. I hear a voice. I'm not sure if I can connect it with a face. Is this Tamara Zakrevska?
We see you and we hear you perfectly well. Thank you very much. We need additional 3 minutes because a lot of people, they are coming from dinner. Just 3 minutes, okay?
Okay.
Thank you. Thank you very much.
Welcome. Oh. Слушам ви, но не мога да говоря, защото всеки момент влизам в конферентна връзка. Много бързо ми кажете. Да. О, не, вижте. Аз винаги съм бил поддръжник на тезата, че освен no
Шановні учасники панелі, покажіться, чи ви всі є? Всі є.
Dear participants, are you all here?
Основний доповідач у нас також є онлайн. Тому я пропоную потихеньку починати. Як скажете, можливо, вам зручніше буде розташуватись за столиками. Дуже дякую.
How will it be more convenient to you to sit at tables?
Шановні учасники, дуже дякуємо за свої
Dear
чесність.
participants, thank you very much for coming back in time. We shall start. We shall plan the panel in such a way that we work up to the schedule. I give the floor to Vitaly Gaseluk.
Пані Лорена буде через півгодинки.
Lorena
Тому можемо розпочинати.
will speak in half an hour. We can start. Now keynote speech. Dear colleagues, I'm very glad to see you all. You came back in time after tasty lunch. I will intrigue you a little. We shall have changes in the program, but I will not tell you which one. Now we work according to the schedule. We shall speak about integrity of the judiciary in search of the criteria for evaluation, indicator evaluation, or other characteristics that help us to characterize this new constitutional category. But same as previously, we had a discussion about counteracting corruption, and then Alexander Vatyakhin wrote, anti-corruptional principle of constitution, although not much is written that about counting corruption, but constitution of Ukraine doesn't provide for provision of countering corruption. There is not true. Same with integrity. Contextually, it was included in 2016. But to say that before that, Constitution of Ukraine tolerated non-integrity and corruption of civil servants and judges, it's not true. And I think that integrity of judiciary should not be reviewed separately from integrity of civil service and society in general. So there is a broad possibility for discussion. The first keynote speech, Integrity of the Judicial, it will be made by esteemed Philip Dimitrov, member of the Venice Commission in respect of Bulgaria, chair of the subcommission on democratic institutions. I hope that Philip is with us.
Yes.
Good afternoon. We are glad
Good
to
afternoon.
see you.
Well, first of all, thank you for this invitation to a conference which seems to be dealing with one of the most unfortunately fashionable issues of the present day, which is connected even remotely with corruption. And on the other hand, I'm happy to be able to talk about the positive side of this. However difficult it is to find positive things when in the general picture you're trying to overcome a big problem. But the fact is that integrity is probably the most personal element of anything that has to be achieved within the framework of governance. And especially as far as the integrity of the judiciary is concerned, it is one of the most, if not say the most, significant guarantee for the independence of the judge. The Venice Commission has had the chance to discuss it, and it has pointed out that this should not be taken as a kind of a prerogative or a privilege of the judge. Integrity is a characteristic, and it is extremely important because without it, independence of the judge is something very difficult. And independence is the guarantee for human rights, and particularly for fair trial, on the one hand. And in the same time, it is what we usually have in mind when we talk about justice. And this is the possibility of the judge to make decisions which fit into the framework of the human understanding of what is acceptable. When I stress upon this, I'm trying to make it clear that the issue of independence of the judge should not be mixed with the independence of the judiciary. To be frank, we are putting a lot of effort into maintaining the independence of the judiciary as an institution. And in fact, most of the prescriptions we are giving are prescriptions which concern how the system of the judiciary can be juxtaposed or put in correlation with the other elements of governance, with the other branches of power. However, the issue of the independence of the judge seems even more important because by the end of the day, it is the judge who makes the decision. And a good judge in a problematic system can make good things. A bad judge in a system, even if it is perfectly well situated, can be very problematic. So when we're talking about the independence of the judge, of course, we come across the issue of integrity as the most important criteria as compared to the others, like qualification, which is an absolute requirement for a judge to be doing his job. The fact that a judge has to have human experience, because this is the only way in which a judge can be guaranteed to take into account the specifics of a case, the human experiences on which such estimation of the specifics is based. And of course, the issue of reputation, I would say a name that is built and has to be defended, which makes it difficult to cross any lines. But again, even if all these three are at hand and integrity is lacking, then the consequences can be there, and vice versa. The level of integrity, which is really high, can at least partly compensate for the lack or inadequacy of one of those elements. However, having said this, the point remains of how integrity can be defined, and evaluated, which means to something very close to measure, but of course, measurement in this situation is not an acceptable concept. The definition of integrity is something that has been tried by the Venice Commission in its compilation on judges. And apart from the general characteristics such as honesty, determination, etc., which are normally known as human characteristics, special emphasis is put on not permitting challenges to A, the independence, and B, the impartiality of the judge. In other words, when we talk about independence, we often have in mind some kind of political influence, but it can be also the influence of some kind of paid activities which create the need for specific vote or something like this. And when we talk about impartiality, we, of course, have in mind most about the conflict of interest. But we can also have some kind of non-direct signals about this in terms of unexplained assets and things like that. So the definition of integrity for our practical purposes to a large extent goes into exploring these issues of lack of hampering factors for independence and lack of hampering factors for impartiality of the judge. This is good to say, but here we come to the issue of evaluation, which is a very complicated issue, and it has become even more an object of discussions in the past few years. There is a compilation on vetting of the Venice Commission. This is 051 from 2012, in which we have put particular efforts into making the distinction between vetting, on the other hand, and the issue of lustration, which is often being mixed with it. The lustration being an attitude towards groups of people who, regardless of their particular contribution, one way or another, show good reasons, exhibit good reasons for concerns that belonging to a different system of thought, to a different conceptual framework, to a different set of values, can be in particular difficulty to follow the needs of the system in which they're incorporated. Vetting is something different. Vetting is examining of current office holders, as in 046 from 2012 on Moldova, the Venice Commission has mentioned. And this is, by definition, estimation on individual grounds. So it has to be distinguished, of course, from pre-vetting too, because pre-vetting is a system in which in advance, before appointing a person to a certain position, the person is being scrutinized and particular issues have been examined to guarantee the future high probability, let us say it, or reasonable grounds for trust that the person will stick to this independence and impartiality and show the necessary integrity. As far as this pre-vetting is concerned, there are a lot of examples of how this can be practiced in the world, and every country has specific forms and different requirements which are set before candidates for future job, including in the judiciary. This, as I said, is something which is somewhat different from the issue of vetting per se, especially among these forms which vetting has, the full-fledged vetting as compared to the pre-vetting. And we have to say that, first of all, this is a procedure which has never been explicitly defined in any international document, which can be explained by the fact that in its essence, it is not a typical procedure. It is visible with the naked eye that this kind of scrutiny of holders of magistrative positions are something which can raise questions considering the most crucial issues for which we're trying to evaluate them. In other words, the issue of independence. So for this reason, as I said, this is not a typical procedure, and it has to be taken, as the Venice Commission has pointed out on its in its compilation on vetting, it has to be taken with particular care, because in fact it usually deals with suspicions of corruption. And as you can well understand, a presumption for corruption vis-a-vis holders of such important positions is something very dangerous and can create serious risks in terms of the functioning of the institutions. So we are here a little bit between two dangers. The one of them being the risk to interfere into the independence of the judiciary, which is one of its most important characteristics, and the other is to permit, under the height of such respect for the independence, to survive practices that have absolutely nothing to do with proper deliverance of justice and with the rules of law. Having said this, we have to move on a very thin ice, and this is why when we discuss vetting procedures and vetting issues with countries who have opted for having such procedures, we are always very cautious and try to stick to very well-defined rules and include some elements which are absolutely obligatory in order not to breach the main characteristic of judiciary which we want to maintain, its independence. So, first of all, vetting brings to the open some very sensitive issues. We have been pointing in our 2022 number 011 opinion on Kosovo that such sensitivities can be a very serious issue in terms of disclosing of how the procedure goes. There has been a long discussion on openness and the transparency of these procedures, and in fact it is true that we in general maintain the concept of transparency of those procedures, but bringing to the open directly some hearings which can imply or even create the impression of something which has not been yet proven, and thus endanger or even ruin the reputation of people that might turn out to have been completely clean after that, is something which has to be taken into account. And for this reason, particular care has to be taken into what can be disclosed and how, on the one hand, the privacy, and on the other hand, the level of proof can be guaranteed. Another issue which we have been mentioning is that sticking to the rule of law, as in this previous case, it is important to take into account the need for proportionality. There is a tendency, which is understandable in some countries, to try to establish as fixed as possible results of this vetting procedures, and to have an either-or decision at the end of the day. This is something which does not fit into the concept of proportionality, and it means that our recommendation in these cases is to have a reasonable margin of appreciation for those entities which are doing the vetting. In other words, not have a fixed punishment for small or big breaches, if such are found out. As long as the issue of the judicial independence is always at hand, our recommendations have always been, and this is very easy to trace in the 09 opinion on Albania from 2016, that there should be clarity that the conclusions that are made and the measures that are taken should not be affected by the executive. In other words, this vetting procedure should remain within the realm of the judiciary in order not to have their independence be one way or another harmed, so that there will not be control or finalization, as I said, on the part of the executive, but also the decisions about this procedure should be taken by the legislature only in the general form. Usually in such cases, the issue of the participation of civil society is raised, and naturally we think that because of the adversarial character of these procedures, there should also be a certain amount of caution implemented. Because, well, it is clear that on the one hand, civil society can bring fresh input and help in such situations, especially if you keep the other branches of power, executive and legislature, apart. It can be a way to get out of the strict framework of the judiciary, which may have certain guilt interests of the guilt of the judiciary involved, and this can bring another element of impartiality. But on the other hand, it is clear that connections with some professions on the part of the civil society, which are strictly exposed to the effects of what the judiciary in general and the particular judges are doing in their practice, can also put dangers of lack of impartiality. And for this reason, with the participation of civil society, particular care should be taken too. The case of some countries, and Ukraine is one of them, as a matter of fact, raised the issue of some foreign participation. And in these cases of vetting, especially in this part which is connected with the issue of integrity, some impartial presence of foreign participants may be advisable. On the other hand, there is absolutely no use of having them there, except if they're given the possibility to really influence the decision, meaning that if a decision can be made without their participation at all, majority is achieved in a way in which the opinion of the foreign participants can be made irrelevant. In these cases, evidently, the aims of such participation will not be achieved. So in other words, our recommendation has been that the significance of the opinion of the foreigners is maintained by guaranteeing it through majorities which will not exclude the participation of at least some of them. Well, when it comes to the procedural standards and guarantees, which is probably one of the most difficult topics, and in fact, we have already got into it. As I mentioned, one very important issue is that this remains within the frame of the judiciary. Of course, the openness and the public element are of particular importance, as has been mentioned. But again, there are pros and cons, and the decisions have to be made with particular caution. One thing which we, by experience, have come to consider important too, is the separation of the performance evaluation and the integrity evaluation. Because once these two are mixed, decisions start seeming very simple, even when they're not. Whether this happens through different panels or institutions, whether by different procedures, but such a separation is advisable. When it comes to the time limits, as it was mentioned, these procedures are, first of all, untypical, and second of all, they signal that a particular change is taking place in general. And for this reason, it is beyond common sense to have them drag for a long period of time. So time limits.
Пане Філіпе, хтось, це саме я повинен...
Esteemed Philip, it's me, the moderator. I'm sorry, I need to ask you to keep within the time limits.
And the last thing I would like to say is that the other thing we recommend is the possibility for an appeal to the respective court of law. Thank you.
Дякуємо дуже за вашу дуже змістовну доповідь, і мені як науковцю дуже
відгукнулося. Thank you very much for your most illustrative presentation, saying that integrity is the guarantee, a safeguard of independence and impartiality, and that the reasonable margin of appreciation should be applied in these processes. Thank you very much. At a later stage, we might have questions from other participants, given we have enough time. And now, dear colleagues, our next presenter is well-known Pavlo Pushkar. He is head of division department for the execution of judgments of the European Court of Human Rights, Directorate General for Human Rights and Rule of Law of the Council of Europe. Thank you very much for joining us. I'm extremely grateful for the opportunity to speak in this wonderful panel. A couple of words about the work of the Council of Ministers with regard to the integrity of judges and prosecutors. Both pertain to independence and impartiality, as esteemed Mr. Dimitrov has mentioned. And it is my task now to comment on the position of the Council of Ministers that creates this practice of the convention implementation, which we call a key on the convention implementation. The enforcement of independence of the judiciary judiciary is a key issue that the Committee of Ministers is monitoring very closely as part of the enforcement of the ECHR judgments against Ukraine in the group of cases Alexander Volkov versus Ukraine, and the enhancement of the independence of the prosecution service is the objective of the monitoring in the Lutsenko case. So in the group of cases Alexander Volkov, the Council of Ministers is monitoring that, and Lutsenko Timoshenko is the group of cases pending consideration in 2024. And we are approaching consideration of issues related to the structural independence of the judiciary and judges themselves, as well as prosecution service authorities. And at one of the previous sessions of the Council of Ministers, in the case of Alexander Volkov, the Council of Ministers entrusted our department to analyze the events since 2013, that is from the moment of this judgment taking effect as a final judgment, in view of the reforms undertaken in response to this judgment. And there are several issues that we are going to raise in this analysis, that we are going to prepare very soon on the Commission of the Council of Ministers. And it is about the legal certainty. The application said that the application of the statute of limitation in disciplinary sanctions was precluded by the principle of legal certainty because there were no time frames at that time. Hence, the judges of the ECHR found violation of Article 6 of the Convention, because the problem, as they stated, was in the threat to the principle of legal certainty and rule of law reflected in this judgment. As far as the group of cases Alexander Volkov are concerned, the system of judgment since 2014 has been in the process of large-scale structural reform, and this reform has been for almost 30 years since Ukraine acceded the Council of Europe. And we will be speaking about the comprehensive reform of the judiciary and prosecution. But the reform based on the ECHR judgment in Alexander Volkov case was a comprehensive reform of 2014-2018. It has been assessed by the Committee of Ministers of the Council of Europe and the Venice Commission, and certain negative and positive elements were reflected in this evaluation. There was criticism, and some of those critical elements were also reflected in the judgments of the ECHR, in particular in Humanuk versus Ukraine.
After legislative changes in 2019, Committee of Ministers of Council of Europe noted several threats to independence of judiciary, in particular structural independence. In the resolution of the Committee of Ministers, the issue of movability of judges was mentioned, as well as issue of vetting judges. At the moment when this group of cases was considered, judiciary demonstrated its readiness to take into account recommendations. And in March this year, government used individual measures. 12 applicants of Kulikov group of cases, as committee ministers demanded, their status was defined. They either were resumed in their position, they were either dismissed or resigned. Judges. In group of cases, Gumenuk and others, Committee of Ministers also noted positive advancement, inclusion of 3 applicants to Supreme Court, created after constitutional changes in 2016, and the resignation of other 5 judges that was confirmed by decision of High Council of Justice. Committee of Ministers welcomed the changes to the law regarding the old and the new Supreme Court according to amendments of 2016. Implementation of judgment of the court in local group cases caused reloading of disciplinary liability institutions that happened in 2016. Legislation that was adopted at that time, changes to constitution, happened. And in March this year, Committee of Ministers welcomed the fact that High Council of Justice, a High Qualification Commission are functioning in full. There is a desire to restore disciplinary function of High Council of Justice and to conclude formation of service of disciplinary inspectors. Decision of Committee of Ministers also mentioned system of liability of judges, not only criminal liability. In 2020, Committee of Ministers used to note that there was Constitutional Court decision about cancellation of part of Article 365 of Criminal Code, which was ruled unconstitutional, and noted that it is necessary to achieve legal certainty and clear determination. What is integrity, terms of liability, types of responsibility, criminal, administrative, disciplinary, and Committee of Ministers continue its supervision of execution of judgment of European Court of Human Rights in this group of cases. And finally, several words about general measures in Lutsenko case that remains under supervision in Committee of Ministers. Here, Committee of Ministers at recent meeting in 2023 emphasized the need of effective safeguards that protect prosecution office in general, in particular prosecutors, from political pressure as regards disciplinary proceeding, career development, and prosecutorial self-governance as important measures of general character for execution of the judgment. Also, Committee Ministers mentioned great progress achieved in reform of prosecutorial office, creation prosecutorial governance body, disciplinary body, and that legislation on this issue was repeatedly made effective. This work continues, so we hope that in the future, as Committee of Ministers pledged, that reforms will be concluded and they will become in line with the Convention and case law of the court and general standards of Council of Europe. Once again, I want to mention that within the framework of this work on analysis of reform and measures taken to execute judgment of the court in local group of cases, Lutsenko case, our General Directorate of Human Rights and the Rule of Law is ready to provide expert assistance to all bodies of judiciary and prosecution office, as well as Parliament, Ministry of Justice, and other partners to ensure full and timely execution of judgments of European Court of Human Rights. Thank you for your attention. Thank you, Pavlo. maybe you can hear there are applauds in the room. And on behalf of all participants, that we uniformly wish you further success in this difficult, ambitious task. And on behalf of the Judicial Self-Governance Body, we can be sure that we shall address you through the projects that work in Ukraine, asking for expert help, and we shall achieve this ambitious goal of financing reform. Thank you. Goodbye. With your pleasure, I will give the floor to Lorena Bachmeier-Winter, International Consultant of Council of Europe, Professor of Law at the Complutense University. Criteria for differentiation, ethical and non-ethical behavior prosecuted. 12 years ago, when draft criminal procedure code was going through the Committee of Parliament, together with Eric Swanidze Bride, Lorena Bachmeier-Winter was providing us support, providing their conclusions that help us to bring it in line with Constitution. That was 12 years ago. Now this code is functioning. It was a kind of revolution. So on your behalf, I will thank Lorena for experience of cooperation, welcome her in Kyiv, and give her the floor.
Good evening. You hear me? Yes. So good evening, good afternoon, everyone. Thank you for being here. Thank you, Council of Europe, for inviting me to this event. It's always a pleasure being here. Someone told me this afternoon, you're a hero coming over. And I said, no, you are the heroes staying here. So thank you very much. Thank you very much for your trust. It's been already 15 years working, trying to help, trying to contribute in my humble capacity to your reforms, to your way towards democracy. So thank you again for your trust. I have to say something. Let me try to say it. Pereposhu sho ne rozmovila, vashoju movoju navit sheres 15 rokiv. So I'm sorry, I still don't speak any Ukrainian. I will continue trying. And knowing that you appear to be obviously very normal life here, allow me to do one thing, which was not prepared, but the Council of Europe was so kind. And this is my little homage to you, very little one, but I feel this is in my heart. So I'm doing this presentation, showing you that I have you in my heart. And now let's come to integrity. Integrity. We have heard a lot about integrity this afternoon. Education about integrity, judicial integrity, how to differentiate between ethical and non-ethical behavior within the judiciary, within the public prosecutor. And I will say, well, we all know the word integrity. And if we come to the definitions, we get a little bit lost. If I get to precise examples, I'm going to ask you, first, what is it? What is integrity? What kind of integrity can be requested to the judges, prosecutors, and how to check it, or how to prevent that they don't go the wrong path and enter into corrupt or lack of integrity behaviors? I'm we were confronted with several cases. Is it against judicial integrity that a candidate judge travels to Crimea? Should this person just be dismissed or even not granted access to be a good judge because of this? Is it against judicial integrity having a judge, she or he, an extramarital affair? Is it against integrity having a judge some drinks with lawyers? Is it against integrity sunbathing naked in a beach where this is allowed to? These are all cases taken out from the practice where we were confronted in saying, how should we deal with these cases? Are they ethical or are they unethical? Is this a conduct that should not be allowed to a judge or a public prosecutor? And allow me to speak indistinctly about judges and prosecutors, because the trend in Europe, as you know, and the European standards is to promote the position of a public prosecutor as judicial authority. Of course, they wouldn't be granted the same level of independence, but the idea is that their education, their background, and their trust, or the trust of the society in them, shall be equal, at least equal, because they are the main stakeholders or the main players in the justice system, one more in the criminal justice system. So what is it and what is not integrity and ethics? Now, how to differentiate an unethical behavior from an ethical behavior? If we go to the definitions, my background is academic, so we always start with concepts. Don't worry, we are not going into very detailed theoretical issues. Integrity is defined as rectitude, righteousness, honesty, morality, and free of fraud, and virtue. Okay, so these are also broad concepts. We can't just describe integrity with other concepts, but what is, to be honest, what is the professional ethics of a judge? What is the right way to behave? And what we know is, first, that the integrity doesn't have degrees. There is integrity or lack of integrity. You cannot be half honest or half right. Second, that integrity is a virtue, but as already stated, and I'm sorry for Council of Europe, but I'm quoting a US Supreme Court judgment of 1962, since the judges do not have the power of this word, nor the power of the purse, their only power relies on the confidence, on the public confidence, and this is based on their ethical standards. So for the judiciary, ethics, integrity is not a virtue only. It's a necessity to legitimize their own power, their own function. And without that, we can keep on talking about rule of law, but there won't be a checks and balances and a proper separation of powers, because that power is not legitimate. So allow me to now enter into more details. Professional integrity. You are judges, and there are a lot of judges here, some prosecutors, and obviously you very well know what is integrity. For the others, they are defined in the Bangalore Principles of 2002, CCPE opinion of 2018 for public prosecutors, the Bordeaux Declaration of 2002, which aligns with the Bangalore Principles, the recommendation on the independence and Accountability and Ethics of Judges of 2010, and so forth. So we have a lot of instruments and a lot of case law. The case law precisely focusing on proceedings, standards on disciplinary proceedings, and obviously linked to the judicial independence and the granting of impartiality. Because professional integrity for a judge, but also for a public prosecutor, is abiding by the law, impartiality, objectivity, respect of human rights, and fair trials. It seems to be pretty easy, no? Abiding by the law and keeping impartial and objectivity. But beyond that, should we look at that behavior only in their judgments, or should we go also looking at the behavior in court and out of court? And this is the tricky point. Where starts the private life of a judge or a public prosecutor, and the behavior in that area may really be considered unethical or against integrity. So once we have seen the definitions and the broad concept, we see it's difficult to go specific. And in going specific, there are no common standards. I cannot give you a precise recipe. This and this and this behavior is to be avoided in any society. No. The perception, the assessment, the criteria. The criteria is perception and assessment depends on community standards, which depend considerably from time and place. So what is unethical here or inappropriate here for a judge to be done, it's perfectly normal in my country. What is to be sanctioned here as a disciplinary offense, like drunk driving, it is not in other countries. So you have to focus in identifying what is to be defined and limit the conduct in and out of court of a judge according to what are the universally accepted principles of propriety and ethics in your context, in your society. And this obviously changes from time to time. I would say that your society has become more strict in some behaviors due to the difficult situation you are living right now. Because when people are dying, then the others have to behave not only according to the standards, but to the highest standards. But obviously the approach to integrity changes from time to time. And I put you just an example. It was very illustrative for me when I first read a book on judicial disciplinary and judicial ethics back 10 years ago. And it was the story of Judge Doddridge, UK judge, back in the 16th century. And this judge, during the court hearings, just fell asleep. It's called the example of the sleeping judge. And at that time, closing the eyes and sleeping, it was considered nothing to be affecting the prestige of the judiciary. It was described as, it would be foolish to pretend that judges never feel sleepy, when some cases are truly soporific. However, the same situation, UK judge just falling asleep during a hearing in 1972, it was defined as, this entails a risk of discrediting the judge and entails a danger and is a negligent conduct. Justice needs to be seen to be done. So we see that obviously everything evolves. I put you a last example to see how the ethical issues and the perception of the society obviously changes along the time and the circumstances. And this was a case in Greece in 1979, where a judge was disciplined because of not wearing the marriage or wedding ring. It was considered to be absolutely inappropriate, like inviting the audience to have an affair. Excuse me, I mean, that would be sounding absolutely irrational today, no? So before assessing in this society how to regulate, how to tackle, how to prevent, how to move towards integrity, let me do one clarification. The consequences of the lack of integrity or the breach of ethics obviously must be different depending the gravity and depending the assessment on these community standards. Though it might be like unethical behavior is sanctioned criminal level, unethical behavior is sanctioned disciplinary level, or unethical behavior is considered just unethical and is not subject to any sanction. What is important to remember is that not every unethical behavior, not every breach of ethics should lead or correlate a misconduct giving rise to a disciplinary sanction. This is specifically stated out in Opinion 3 of the Consultative Council of Judges in these paragraphs 60 to 62. So unethical behavior does not mean we have to sanction a judge. We have to differentiate. If this entails disciplinary proceedings because the unethical behavior is too grave or too serious, and it should be avoided because the whole judiciary is prevented from or is causing distrust, or you should abide by these ethical standards, but this does not entail a disciplinary sanction. So now we come to the tricky points. What conducts might be perceived as unethical? How to assess it? Because I was asked to present criteria. And the criteria is what should, like in law, in so many areas, like Roman law said that the good pater familias. So we don't use it anymore because it's against gender equality, no? Pater or mother familias. But what is the standard? And we don't have a precise standard. We have to resort to this perception by a fair-minded, reasonable, informed observer of the community that considers that such conduct is likely to diminish respect or trust for the public prosecutor or the judge. So we resort to the position of this reasonable third observer that knows the community and knows what are the standards of the community. So in the view of a reasonable observer, what kind of conduct would be unethical in a society? Obviously, we have a common standards and agreement. Conducts that entail criminal liability, of course, they are unethical. They should be avoided in any event. With regard to disciplinary offenses, there are some different approaches. And with regard to what shall be looked at, only private or only private and public approach, or only private? And there we find also a huge difference. Again, there are no general standards, but we will try to figure out some criteria. The test is, and this is, for example, the Spanish approach. Whatever a judge does in his or her private life, and does not have a direct impact in his or her job as a judge, we don't care. We might like it or not like it. So he or she can go to the beach in naked or can do karaoke in nasty places. That's his or her private life. In other countries, in other societies, they will consider, no, this is against the dignity of the profession, and this will be perceived by the community as absolutely unacceptable. So on the scope This would be perhaps the position in Germany. A judge crossing the street with red light is seen like you are not giving a good example. You should be an example for the society. Or drunk driving. Drunk driving, okay, if it's an administrative sanction, it's not nice in my country, but we have very good wines. Yes, it's true. I mean, Vega Sicilia, Ribera del Duero, Rioja, they are good wines. I'm not doing advertisement, but it's not nice. But okay, it's an administrative, it's tolerated by the society, and this does not lead the third observer to consider that they cannot trust in the judge when doing his or her job. 6 factors. 6 factors are considered as useful to assess unethical behavior, if it's public or private, if the conduct is not is protected or not protected by an individual right. So like freedom of expression. Freedom of expression, judges have freedom of expression, but they have certain limits, no? But you cannot deprive this fundamental right from them. The degree of discretion, if the conduct is harmful, so in cases of gender violence, there is 0 tolerance. This is absolutely whatever the kind of conduct, if it entails gender violence, in my country would be like you are discredited as a judge and you are discrediting the judiciary as a whole. Lack of respect of the members of the community or other conducts that are indicative of bias. So finally, and I'm finishing, I should finish, no? I should finish already. Finally,
I don't want you to do it now, but we have to, you know.
And what do I have to do within the ethics?
Only within these margins.
Okay, I'm finishing. Important. In order to preserve and protect the independence of the judiciary, what entails sanction as disciplinary sanction has to be very narrowly defined. Principle of legality in criminal law applies to administrative sanctions, punitive sanctions, according to the Engel criteria set out by the Court of the Court of Human Rights. So this idea, and this has to be changed in your codes, be it Article 43 of the law on the prosecution, be it Article 106 of the law on the judiciary. A breach of morals and a breach of code of ethics as such cannot be defining a disciplinary sanction. It needs to very well identify and precision in the definition. Finally, it's important also behavior within court. I put you an example that we were discussing a conduct of court, a judge just expelling a lawyer in a Moldovan court because he was not wearing socks, or their socks were yellow or something like that. So is this, what would you say? Should we discipline the judge? Or should we consider this unethical? It depends on the socks, no? So we leave it here. There's a lot of work to keep on doing in preventing integrity. I mean, I do not have time in entering into the integrity checks that are being in place and how far and how deep they should go into the private life of a judge. But I am absolutely confident that you will find the way. Thank you very much for listening.
Дуже дякуємо, пані Лорена. Колеги, я думаю, ми тепер
Thank you very much, Lorena. Now, I think we understand that we should be looking for a reasonable and external observer in the right color socks. And I will give the floor now to Volodymyr Petrakovsky, consultant of the Council of Europe, expert of the Council of Europe, lecturer, National University Kyiv-Mohyla Academy. He will be speaking about integrity assessment criteria in the context of the Council of Europe standards, judiciary and prosecution. And we said that integrity is a guarantee of independence and impartiality of judges. Thank you very much. You mentioned that Lorena had certain relation to the Ukrainian CPC adopted in 2013. She also contributed to the adoption of the 2014 law on the prosecution. And she also provided comments as an international consultant. And later, she also commented on the adopted law. And I would like to underscore that next year we will mark the 30th anniversary of Ukraine's accession to the Council of Europe. While acceding to the Council of Europe, Ukraine undertook it to turn Ukrainian prosecution into the European style prosecution. Next year, we will have an opportunity to discuss what was meant by the European style prosecution. Today, it could be a very interesting topic for the discussion, but today we can be speaking about the following. The core of the new European-like prosecution is independence.
Перебуває у них на виконання рішення Луценко проти України, яке стосується
Pushkar mentioned already that Lutsenko case is still under supervision. And I agree with Pavlo. We are very close to execute judgment of the court in this group, but taking into account recent scandals with prosecutors, we still wish to go different way and to avoid mistakes that we made in 2019. And to avoid these mistakes and not to complicate our life, not complicate Pavlo's life, because his job is to enforce these judgments, many other judgments. We must communicate certain things. But first of all, I will speak about integrity, because integrity is the main topic of this panel. I do not like this Ukrainian term. I do not understand that honesty or is not enough. Доброчесність Ukrainian is not clear for me. English integrity is better for me. Ambassador Dysyuk, who gave interview to Kiev Post, he said in Ukraine there is integrity and hyper integrity. So I think it's rather integrity. So in Ukrainian, I will use the word integrity. When talking about integrity as important component of standards of Council of Europe, it was mentioned by Lorena and other previous speakers, in all key documents of Council of Europe and judgments of European courts, recommendations of Committee of Ministers, opinions of Venice Commission, principle of integrity and integrity checks included in the document Basic Underground Concepts, Black Letter of Council of Europe on that. This concept is already in there. So this is the concept that is an integral part of Council of Europe as regards judges and prosecutors. Moreover, next year, 2025, Greco will start its 6th round of evaluation of the country, which will pertain to integrity matters. Ukraine will not be in this round because Ukraine is still on the 4th round, and Greco will surely develop some additional models or examples what one should do and what should not. In principle, this model has already been offered by European Court of Human Rights. Case mentioned here, Gumenyuk and others versus Ukraine, European Court mentioned quite correctly, Convention is not an obstacle for the state to take in necessary legal decisions to reform judiciary. However, the court should check whether the way the reform was conducted impacted rights of applicants. The issue that integrity is the basic concept of European law. Still important is how this integrity is achieved and checked, and what will be the reaction to it. Why I mention reform of 2019? After the law on primary measures to reform prosecuted office was adopted, Council of Ministers and Greco responded very negatively. Their reaction had one important aspect. Council of Europe will not accept the way how reform and attestation of prosecutors was conducted. It was conducted through termination of functioning of self-governance bodies. For Council of Europe, it was a red flag. Such important aspect as integrity check, discussion of this issue of integrity be conducted without participation of prosecutorial self-government bodies. When we speak about integrity, about raising integrity of judges and prosecutors, accordingly about integrity check, we must realize that in this package, prosecutorial self-government bodies should be included. No attestation, re-attestation, or any check cannot be conducted without self-government body. This is important aspect that Ukraine should take into account for the future, avoid mistakes of 2019. Last but not least, what was mentioned before, what Lorena emphasized, Council of Europe offers certain set of things that should be taken into account during integrity checks. You can find it in conclusions, opinions of Venice Commission on Ukraine. Most of you don't remember that. In 2015, there was the law on integrity checks, and Venice Commission has compiled number of recommendations that government should take into account. I shall read them quickly. Allow you to think about it. First, integrity checks must be in line with international and European standards. If you speak about checks of prosecutors and judges, only through self-government bodies. Second, that Pavlo emphasized, principle of legal certainty. This is also a key aspect. Two other things emphasized by Lorena. There should be clear, distinguished criminal, administrative, disciplinary liability on other reactions to integrity check. There should be very clear separation, demarcation line between them. Even if these lines are vague, types of responsibility somehow across. After integrity check, both discipline, criminal or administrative measures will be used. From the very beginning, there should be certain safeguards regarding that. If after integrity check or disciplinary responsibility follows, all the safeguards should be provided. There are recommendations made by Council of Europe in cooperation with Ukrainian side, and we have to fulfill them. I hope that will be done next time, and group of Lutsenko case will be closed by that time. Thank you. Thank you, Volodymyr. Dear colleagues, we continue. Give the floor to Sergei Borlakov, member of High Council of Justice. uniform indicators for assessing integrity. This issue was mentioned several times at September negotiations, when these indicators will be developed and how we'll use them and what consequences. Allow me to give best regards from High Council of Justice, from our chairman, and thank you for the invitation to participate. I'm very glad to see colleagues in this room who were also members of the working group who elaborated this uniform indicator. Tali and other colleagues, you know that according to Part 6, Article 83, first at legislative level, a Council of Justice got the duty, together with High Qualification of Justice and with Public Integrity Commission, to define these indicators for judges and candidates. So from vague philosophical categories, we switch to legal categories, answering to the question when that happens and why it took such a long time. First in the working group, now it's discussed again in the High Council of Justice. When these indicators will be improved, quite soon they will be adopted. In fact, it will be a certain mix and compromise, and the topic of today's panel about balancing. We tried to balance and to achieve certain joint criteria that will present to the public. In fact, we shall be forced to work with this criteria as High Qualification Commission of Justice, as High Council of Justice, and Public Integrity Council during assessment of candidate, in disciplinary proceeding, and it gives certain legal certainty to avoid different approaches in procedure. On the other hand, it makes a number of challenges for developers, and I will explain why. The need to work with this concept, integrity, moves us to a kind of gray zone of correlation of morality and law. If colleagues emphasize that this criteria must be uniform, that must be well defined, not to bring to ambiguity of interpretation, then it will be legal fiction, but they will be legally defined, and according to certain templates, we shall assess behavior of a judge according to certain standards, and this requirement of formality will be achieved soon.
But in this case, and that's not just my opinion, most of the members of the High Council of Justice share this opinion because it is based on the basics of philosophy, in particular philosophy of ethics. So it's too easy to substantiate formally the definition, and any candidate or the incumbent judge with a certain level of competencies and qualifications would be able to find certain correlation with the formal definition. And as Lorena said, the society is perceiving the judges. And in this case, when the society would see a certain violation or non-ethical behavior or non-integrity behavior, you do not see any obvious things because it doesn't fall under the definition. So this is a minus of the formalistic approach, whereby you find just the ticking of boxes, whether the requirements have been fulfilled. There's a different approach when we, unlike in the formalistic approach, we go to the sphere of moral intuitions, but then there's another risk because moral intuition is related to certain societal trends, and whereas the norm of law is unambiguous, there is no unambiguity in morality because there is a whole range of moral or immoral things. It depends on societal attitude, on religious convictions, on age groups, on social groups, attitudes, etc. So the requirement to the formal law clash with the moral layers of the society where each group has got its own set of moral principles. And if we introduce moral categories, then a question arises, who will be establishing those moral priorities? And should there be a group vested with powers by law, say, for the vetting of the candidates to judicial positions and nominating certain candidates to the president. And again, we go from objective to subjective criteria. Moral criteria would entail a group of persons, individuals who act guided by their internal convictions. But are they moral authorities of the society? If we have to be guided by certain moral authority, then it takes us away from the formal definition to the even deeper subjectivity. So the challenge to the working group is this. So we in the High Council of Justice are actively discussing these matters. And the Congress of Judges agreed on a new version of the Code of Judicial Ethics. It was done very publicly. A lot of judicial associations and societies had a say. And finally, the Congress of Judges approved this Code of Judicial Ethics. Then the question is, how does this correlate with the integrity criteria as defined in the law and with the code of disciplinary violations, and how can all of that be brought in a certain unity? Because there might be no various criteria, say, as defined by the code of conduct, then by law, and then by professional ethics and extra, say, hours behavior or behavior in private life. So, of course, the reasonable person should be the one who assesses. And now the definition of the notion of just usual reasonable individual is not part of the Code of Judicial Ethics as approved by the Congress of Judges, because there is no average understanding of morality, because as I said before, each social group has its own understanding or perception of morality. Some act within the ambit of some religious norms and requirements, and that does not take into account the research and scientific developments, whether the behavior of an average reasonable individual sufficient and reasonable as seen 10 years from now. So that's the challenge facing the High Council of Justice. And even when these approaches are approved, it will be just the next step. And Lorena, we missed you. We missed you immensely. We needed your knowledge, your approaches, your integrity. So I'm glad that you are back, and I'm always open to talking to you. Thank you, Sergey. I think that perhaps we should start a discussion on setting up a register of such criteria. Thank you very much for your presentation. Now, Oleg Kolyush, member of the High Qualification Commission of Judges of Ukraine, the one who will be obliged to use those indicators. So I will give the floor and the remote control to him. We work in the same panel. Yeah, I wish you could also teach me how to use this remote control. Thank you very much. Okay, Oleg, just a moment. We've got, say, up to 10 minutes. Should you have questions, please prepare them in advance. Your questions or comments. Right, so you reduced my presentation in time. Thus, it is very difficult to speak after such powerful speakers about integrity, but actually this is a limitless topic, so perhaps I would now translate it into more practical approach and try to answer the question whether it is possible to measure integrity in a certain score. The answer would be no, but we Ukrainians are looking for difficult ways to address issues, you know, when we implement international practices. And not only did we digitalize the category of integrity, but we started to assess it in points according to a certain scale. Let's discuss to which extent it is well grounded. So now very soon we are going to apply these indicators during the competition for the judicial position. So we will have to somehow assess their integrity. And the question is whether we can apply certain score to this assessment. Let's look at the law on the judiciary and the status of judges. Now it won't work. Good. Great.
Ми бачимо, що у доброчесності
So we can see that the integrity is characterized by a number of indicators for assessment when we apply it to a certain incumbent judge or a judicial candidates. And these indicators and the ways how to establish them should be approved by the High Qualification Commission of Judges. And that's what we will have to do very soon. But when we speak about unified indicators for assessing judicial integrity, those are to be established by the High Council of Justice. When it comes to the definition of integrity by law, then the assessment of this criterion has been introduced through a number of indicators approved back in 2016. And I would like you to have a look at the number of indicators that we discussed at that time.
Гаразд. Технічні негаразди, то доведеться розповідати так. Цими було передбачено низку показників, за якими оцінювалися.
A whole set of such indicators were considered, and the most interesting thing is that the assessment of professional ethics and integrity provided for a broad margin of appreciation of the Commission while assessing these criteria, and the weight of professional ethics and integrity in the overall assessment during the qualification assessment in general was higher than the qualifications and competencies of the candidate. And there was another gap. The higher weight of some indicators could be set off by other indicators. For example, if the candidate has a high score with integrity and very low score with professional qualifications, then in the future, the candidates could get the same score, but that would be very different in essence. So that raised the question whether it was at all worth doing. So the first step has been done with the regulations on the qualification examination. That regulation revised the weight of indicators of their qualification requirements or competencies. It's 400 points today, unlike 300 in the past. And now the Commission is discussing whether the integrity should be assessed in certain points as a score. As Lorena said, you cannot be cannot have half integrity, like you cannot be half pregnant, right? So is it possible to establish or ascertain whether a judge or judicial candidate is a bit honest, a bit independent, or fully honest and fully independent, or are these indicators valid in general? My personal opinion is that I would be assessing integrity at the following formula: plus or minus, integrity present, integrity absent, whether they confirmed that they have integrity or whether they didn't. So this definition can be a black ball or blacklist for any incumbent judge or a judicial candidate, but still it will enjoy better confidence and trust on the part of the society. It will ensure the adherence to the principle of legal certainty, because when a candidate is running this contest, they should understand against which criteria they will be assessed. And this approach, I think, will ensure this legal certainty. Then the criteria of integrity are extremely important, given that the role of the judiciary in ensuring the law-abiding state and the rule of law. At the same time, we need judges with both integrity and good qualifications, rather than almost those who almost have integrity and almost have sufficient qualifications. So I think we should revise the assessment procedures, because the presumption of integrity is not yet recognized. We are looking for people with integrity, but we do not look at examples of behavior with integrity.
Our provision on qualification assessment will be soon adopted, I hope. All legal professionals will get engaged in discussion, and we shall find the proper way to select judges with integrity and competence. Thank you. Thank you. If all legal professionals are engaged, this procedure of finalization of the document will be very long. But the code says, if you promised the participants to have possibility to ask questions or make comments, do it. If you have some questions or comments, please, you can do it now. I'm Mykola Mazur, Judge of Supreme Court. Sergei, in his presentation, said there could not be different integrity for judges and candidates for position of a judge. And Oleg, in his presentation, showed us criteria that are a bit different. I think that as a general criterion, in a general form, they could be similar, but results of assessment can depend whether this is a private person that is a candidate for position of judge or it is a sitting judge. When judge is taking the position, he or she takes the burden of all restraints connected with this position. Certain types of behavior will be quite normal for a private person, but could not be judged as unacceptable for a person who is already a sitting judge. I would like to hear your reflection. Maybe you will specify what you said. There should be one integrity or different integrities. Thank you for your question. There is a very profound sense in your question. The legislator said that candidate and judge should meet the criteria of integrity and professional ethics, and they should be distinguished, as Lorena was saying. Ethics is a certain standard invented by professional group of people, approved for a certain period of time. With the change of public opinion, with change of approaches, with change of legislation, with change of case law of European Court of Human Rights, this corporate standard is changing. There is a certain external impact of rules at a certain professional group. The other criterion of integrity means personal qualities of an individual, such as honesty, diligence, independence, rules not prescribed by someone. These are the characteristics of an individual, and we must assess these characteristics of an individual, and for that, there are certain cognitive tests that candidates will pass that will allow us to assess level of his or her personality and personal qualities and should not be confused with corporate standards established for a professional group. Of course, when we assess a candidate who is not a judge, comes from different aspect of legal profession, the human characteristics of integrity. Well, if the behavior of legal advisor was in line with his previous profession, where he went in a law firm, whether that person was behaving in line with these rules, whether behavior of a prosecutor was in line with the rules established for prosecutors. In academia, whether the previous behavior of that person was in line with the requirements for that community. I would separate it and characterize like that. Anybody else? Students community, please ask your question.
Вітаю, шановні спікери. Дякую перш за все за таку промову і цікаву дискусію. Але
Esteemed speakers, thank you for your presentations. But I will address my question to Lorena, and I will switch into English.
Express, I think, as everyone in this room, my biggest gratitude for such strong support of Ukraine in such hard times today. And secondly, coming back to your speech, you have mentioned very interesting things considering the question that we should take into consideration the behavior of judges not only in the court, but also out of it. And I think for me, as for each lawyer in this room, here arises the very clear statement that it would be a fundamental breach of the right of person to the private life. However, on the other side, you have also mentioned that such thing as the dignity of profession. And here, my question arises. What do you think, from the very subjective point of view, what should prevail in Ukraine in order to achieve this clear, strict, and strong justice and legal system? The right of private life of judges, as Ukraine is a democratic country which protects and provides its citizens with these common rights, or the dignity of profession? Thank you.
Thank you very much for your question. The answer would be, the clear answer, the honest answer, the ethical answer would be, I don't know. Sorry, but it would be absolutely arrogant in my position to say what is better for your society, because you are the ones who know better. It is true. I've been coming and going and knowing your laws for the last 15 years. But it depends on, this is the music of my alarm, sorry. And it's distracting me, sorry. It depends what is the society really requiring now. In my view, my subjective view, my desire, my position, not yours, I prefer to keep private life as long as it does not directly affect the capacities and the professional trust. I would leave it outside, because I very much cherish the freedom and the private life. And the US approach would be quite different. If you behave in court in a way and outside in another way, you might be seen and perceived by your society as an hypocrite. So you are not to be trusted. It depends on the perception of your society. The other day we were discussing about this drunk driving. No way, not even one glass of wine. And then we started saying, okay, drunk driving, but if it's only one glass of wine, what would you do? Would you trust that judge? Not an alcoholic, and behaving correctly, the best one in providing judgments. And was caught once because 0%, a little bit more in driving, 2 beers. What do we do? It depends on you. If they have to give a great example, another example, you have in Europe asset declarations and the integrity checks which are based on, sorry, but from the outside is a little bit kind of naive. You have to put a box if I have committed an act of corruption, yes or no? No. Obviously, everyone says no. I mean, what do you ask? This is like traveling in the US in the past. Are you a communist? No, sorry, no. Otherwise, you are not allowing me to enter. No. But for example, the value a society has in lies, in telling the truth. Every people tells lies, all of them. How nice you look. No, you don't look nice. You look horrible. But everyone says lies in their life. What kind of, another thing is, I'm lying about having a doctoral degree or a medical, because that is harmful. Okay, so you really have to adjust it. My point is, don't be too strict with private life. because otherwise you will be facing another problem. No one will want to be a judge. I mean, transparency is important, example is important, but please allow me to live also and to have my family. Does it mean we had one issue also in my country, the judge shouting at the wife at home, but the neighbors heard it. And this is a judge someone wanted to get rid out of the case. Oh, they are violence, gender violence, domestic violence. Would you distrust someone? Because every one of us shouts one in a while. It's not nice. It's not nice. But there's no single person that does really abide by every ethical principles all the time. All the time, no. So I would say prevail private life. But if you need to go stricter because of the circumstances, go stricter. It's not for me to assess. Sorry for being too long. Thanks.
Дякую дуже. Шановні колеги, я на вимогу...
Thank you very much, dear colleagues. Upon request of the organizers, I must be arbitrary moderator. Let us thank all participants of panel discussion. Now we have coffee break. You can continue your discussion, and then we start next panel in 10 minutes time. Thank you.
Перепитала, він сказав, що він пару хвилин йому потрібно, за секунду підкупити цей. Я віддам йому. Наступний зараз?
Шановні учасники, ми розпочинаємо нашу сесію. Я прошу всіх зайняти свої місця. Запрошую на сесію про майбутнє. Про те, яка у нас юридична освіта і що ми можемо очікувати в майбутньому від правників, які війдуть в систему і насправді будуть створювати нашу з вами старше життя. Да? Не хочу сказати пенсію, але старше життя. Передаю слово пану Расіму, модератор.
Дякую, пані Ірина. Насправді, браво тому, хто придумав назву цієї секції, про те, що верховенство права в державі починається з якісної юридичної освіти. Верховенство права починається з освіти, наш захід закінчується освітою. Здавалось би, протиріччя, але ні. Чому? Тому що кожен фініш – це, по суті, старт. І підводячи підсумки того всього, що ми почули, нам здається, що багато того, що почуто, було може і мало б бути імплементовано
should have been implemented in educational process. All that pertains to subsidiarity, and maybe education will give answer to the question asked to Verena Bachmeier. Where can we find balance between personal life and the public obligations the certain position imposes when looking broadly at that? Case law of European Court of Human Rights is implemented in educational processes. In fact, our job is not to teach our students what European Court ruled in the judgment pertaining to 1976 or in the modern judgment. Important is to bring to our students the main approaches used in Europe. We see Europe in European Court of Human Rights, in European Court of Justice, in Supreme Court of European Union countries, and we want to see Europe in our courts as well. Every judge is a judge of human rights in Ukraine, and such messages impose great expectation from legal education. A month ago, we were in Brussels at negotiations regarding Chapter 23, Rule of Law and Fundamental Human Rights. Mikhailo Shumilo, present here in this room, was talking about legal education. European Commission is expecting from us relevant reform. And here I want to emphasize that this reform is expected in the chapter rule of law. Therefore, great victory is that in such high level today's forum, this topic is present in the agenda. I will represent the speakers one after the other when I give them the floor. We have here Marta Marchulska and Oksana Valchilchenko, and 3 other speakers will join online: Volodymyr Venger, Svetlana Helyuk, and Yuri Barabash. So we shall start, and time is limited, not more than 10 minutes for each speaker. My first question to Marta. What are your insights that you got as most interesting today? What is the way how to build rule of law in education process? No input. She doesn't speak into the microphone. Her microphone is not working. No input.
О, тепер я вже сама себе чую.
Now I can hear myself. Colleagues, today's event inspires me as a representative of one of the legal schools in Ukraine. Invitation of students to this forum shows what attention should be paid to develop legal conscience of our students. Reading a report on Ukraine from European Commission, I defined certain elements that European Commission defined as most important. One of them, change of educational curricula with the greater focus on EU law and ethical issues. So ethical issues should necessarily be raised in law schools, at universities. So this is not only the development of knowledge and competence, but this is also ethics. This is acquiring certain skills that every lawyer should possess. In my view, we should pay attention to this. And reform of legal education that is lasting for quite a long time is coming to some legal conclusion. We look forward to adoption of the law, finally, which will define the main pillars: master's degree, bachelor degree, requirement to the graduate, set of competencies that he or she should possess, and profound knowledge in the sphere of case law European Court of Human Rights should be provided by all law schools, because this is our future, but also communication skills should be provided for the proper of self-realization in a legal community. Thank you for your answer. I think that every educational court should include a discipline of case law of European Court of Human Rights or standards of Council of Europe. When talking of rule of law and its correlation with legal education, recently I attended summer school with my students, and there was a panel on rule of law, understanding of main principles of rule of law. And before presentations, we asked students a question. What do you think? Rule of law, is it a theoretical concept or practical concept? We were surprised to see almost uniform answer was that this is a theoretical concept. In opinion of students, they didn't see its practical implementation. I hope that after the end of this discussion, we manage to change it somehow. But I would like to ask Oksana, how you see correlation between these two elements, how they help each other and interact. Thank you, Rasim. I think that all colleagues will agree. What do we mean by high-quality lawyer? What is education of high-level law? I think there are two components of that. What we discussed, high level of legal culture. I think that lawyers face this problem. There is a distorted perception of law as a social regulator. Some citizens abide by legal nihilism. Law is not effective regulator of processes in society. I met a term legal romanticism, legal ideasism. They believe that we adopted a certain provision, and this is an ideal regulator of public relations.
Студенти, здобувачі освіти, вони є невід'ємною частиною суспільства, вони з такими настроями приходять в заклад вищої освіти.
Young students come to our educational establishment with this mood in mind. I think we must teach them how to find the balance, importance of rule that help to regulate the issues that are important for society and the state. I would like to differentiate three aspects. This is legal nihilism is a kind of psychological defense of a person. A person is justifying the fact that it's violating certain rules. By that, we are paying attention to rights of a person. On the other hand, we do not diminish right of a person. We must pay great attention. We must discuss limitation of limits of freedom. Legal principles, they have. We always say to students, if you learn Constitution of Ukraine by heart, don't think that you become a lawyer. Legal profession is unique. As Marta said, skills must not be just linear. Not only know how to use norm of law properly, when talking about training high quality lawyer, we must teach them what are the modern trends of development. They must analyze and predict.
They should not be implementing reforms for the sake of reforms. They should understand the aim of legal regulation. They should should understand not just the current trends, but also how to avoid negative impact of a certain legal event, how to reduce the destructive potential or prevent the negative impacts. They should understand the quality of a certain act of law. They should understand how in decision making on a certain provision of law, a certain legitimate aim can be achieved.
Парламентський вислів зараз підібрати щодо сучасного нормотворення, коли ми говоримо, щоб була відсутність.
When we speak about the absence of gaps or loopholes in legislation,
такого, знаєте, суперечності норм права,
avoidance of conflicts of norms within the entire legal framework. This is about the quality of legal professionals, and we should show them how the legal theory and practice evolve, what challenges they might face in their professional activity day in, day out. When Mykola was speaking about subsidiarity, he underscored that there should be regulated principles of tolerance, of proportionality, and it's incumbent on us to convey this understanding of principles to them, for them to understand how it can be regulated not only in judicial practice, but also in the operation of all branches of power, executive and legislative alike. So all authorities that deal with justice and enforcement of law should be acting hand in glove. I understand that all of you will have your own understanding of the rule of law, because both formal and contentional or the content-based understanding is what exists today, but the ones who will be developing those notions are the students, when they would fill in every category with very specific legal content. It is only then that we will be able to speak about high quality of legal education. And then something that pertains directly to our activities is how professional knowledge and skills are developed in our students. And we have to demonstrate it to the students that all phenomena that legal professionals might encounter are versatile, are multifaceted, and sometimes are very complex. Thank you very much, Oksana, for your intervention. I think that somewhere when you were speaking, a student who learned half of the Constitution by heart started weeping. Now we speak about the theoretical component of legal education, and the Supreme Court introduced the concept of engaging with the legal schools and universities, and we offer master classes to the students, and very soon we will announce the first moot court trial to be hosted by the Supreme Court early next year. We also come up with a number of other initiatives aiming to
Pursue
three aims: ensure openness, ensure uniformity of court practices, because education is not just about the rule of law as the overarching principle, but it's also about the legal knowledge that is up to date. And we believe that justices of the Supreme Court are the best speakers who can impart this knowledge onto students. And we see that judges are prepared and willing to spend their time with the law school students. Now, continuing our dialogue with our esteemed speakers, I would like to give the floor to Volodymyr Wenger and ask him about the following. In your opinion, Volodymyr, what should be the balance between theory and practice at the senior years of law schools of the university? Should it be 50-50, 80-20, or 20-80? What's your opinion on that? Good afternoon. I greet all of you. I hope that you can hear me. Yes, we can. Thank you for the invitation, our most interesting event. And this topic is extremely important, and it should make us think about the future development, not only of the legal education, but also of the legal profession in general in this country. It can sound a bit lofty, but without high quality cohort of legal professionals capable of ensuring and promoting the true rule of law in this country, we won't be able to speak about the total victory and the true victory, because the destruction of the public institutions, rampant corruption, unfortunately, these terrible impacts on the morale of society, on the way of thinking of people in the street, of regular citizens, and legal professionals should be corrected. And the role of the independent professional court, the role of high quality professional bar should be leading. And answering your question, I should say we cannot turn a blind eye to the challenges and requirements of today. So I don't think we would be able to find a reasonable proportion in numeric expression, but practice should be the token of the true professionalism. Not only am I speaking about the procedural protection of the people, because in most countries the mechanism of the prevention of legal conflict are at play, and if those conflicts arise, then there would be alternative dispute resolutions at play. So I think that legal practice should be a prerequisite and a task of developing legal profession and legal education, not only when it comes to the enforcement of laws, but also a theory. Today we see that there is this huge gap between the activities of well-renowned academic institutions and oftentimes the imitation of research activities, particularly at the tertiary level, at the level of the postgraduate studies. And there are problems that we still have to address. And practice, legal practice in the broader definition of this term should pertain to the change of the education standards, education processes, and the way we teach. So I think that from the standpoint of the rule of law, it should mean that curriculum, particularly when it comes to professional curricula, in most of the law schools or law departments, they should rely on the needs of the legal community and the market. Today, the education standards define major competencies that enable the institutions to adjust their education processes with more focus on a certain topic or section of law. Some law schools do it, some pretend that it's impossible, but to me, one of the most important factors should be the engagement of legal practitioners to teaching, co-teaching and training, or as guest lecturers. And they should also contribute to the development of courses and curricula.
Практикують такі цікаві підходи, як співвикладання цілих курсів.
Many law schools practice such co-teaching. They have some point courses, mosaic courses. Different universities call it differently. For me, it is a good possibility for practicing lawyers to come to them and tell something interesting. Very often, maybe they are propagating their ego, but here you also must look for reasonable balance. But teachers who directly teach should respond to new demands of profession. From legal point of view, it's difficult to do because workload such that you can hardly fulfill all these things. If you do it, then it will create problems. But this is the future as the choice of optional component. Only few universities and law schools have selective optional courses that allows to develop market competition between the teachers and the university. Each teacher will try to offer more quality product. And students will pick up what they like most. When talking about engagement of practitioner is internship programs. I thank to Rasim Babanli and Supreme Court for this possibility to join new initiatives offered. We signed a memorandum on this new initiative, but legal practice that existed previously and continues in many institutions now must be changed. We need new formats of professional mentorship, or maybe internship, not only sending our students to work in governmental bodies or legal institutions or business, development of clinical education. The wave that we experienced at the beginning of 2000 is exhausted, and the work of law clinics requires new sentence, new instruments for development. Same way, we can speak about non-standard formats of teaching certain practical courses. American experience gives us grounds to believe that this approach to organization of educational process can be explosive in the full meaning of this word, not only for one cohort of students that took this course, for entire law school, for its competition with other law schools. Last but not least, you can hardly have quality legal education without normal quality academic potential. With that objective in mind, Ukrainian academia must be linked more and more with legal practice, with legal business, with the demands of legal market. To find an interesting academic article that gives answer to relevant questions of law practice, judicial practice, it's extremely difficult to find such an article. Here, I think the state should make steps as regards development of quality requirements to academic studies that are financed from the budget. Formation of the topics of their studies for several years in advance. Academy of Sciences, scholars should be involved in that, but without academic potential, with their integration with the Western world, we don't have a success. While finalizing
легенда сучасної
speech,
філософії права професор Тімоті Ендікот
famous Professor Timothy Endicott said, what is very important for joint quality development of the legal community is to read same books, same profoundly. In conditions of Euro integration, we can hardly say that all our students and all our teachers are reading same books. Same in the good meaning of this word. Same that their colleagues and students from European university, even in Eastern Europe, to say nothing about Western Europe and USA. We have many barriers not allowing to do it. English language, way of thinking, absence of human and financial resources. These are very important factors that can bring together practice and theory. Rasim, I spoke less about the rule of law, but more on practice and theory, but I hope I answered your question. Thank you. Thank you, Volodymyr. It happens so that the rules of law covers all those things that you mentioned, that your last remark is not contrary to what you said before. One should read, of course. We should read same books. And using this opportunity, I ask you to read reviews of European Court of Human Rights in Ukraine. If we all start reading that, that will be the first step for us to read same books that Europeans read. Svetlana, you are with us. I want to give the floor to you. When we were preparing for this forum, you mentioned that sometimes ago when someone started to introduce course of European Court of Human Rights into educational establishment, that person was told you must go to Strasbourg and introduce this course there. Court is there and practice should be studied there. Whether this approach has changed now, what are the key aspects that legal education should be reformed? Maybe not legislation, but rather soft things that could be used in short or medium-term perspective. Please, the floor is yours. Thank you. I thank colleagues. Thank you, Rasim, for your question. Thank you for organizing this forum for so many years, bringing together specialists from Ukraine, from all over the world for discussion of such important things as the rule of law. Special thanks for finding place and time for conversation about legal education. European Commission was quite right when they wrote it in their conclusion. Coming back 10 years ago, 10 years ago, I am here and Strasbourg is far away. This sentence could be used very often in the court, academic circles. Convention is relevant when you reach the European Court and you defend the strengths of your client or interest of the state. Within last 10 years, situation dramatically changed, and the certain individual courses or components devoted to conventional law is included in curriculum of most of law schools, and this is a great achievement. Coming back to the concept of rule of law, it's due to studying case law of European Court of Human Rights and conventional law. This theoretical concept acquired practical significance. Through case law of court, both students and sometimes teachers and practicing lawyers can feel how rule of law is realized, how this principle can potentially impact life of every person and how it is implemented in practical situation. When talking about importance of convention for transformation of the content of legal education, I don't speak about format, about normative regulation, but content. It's difficult to overestimate it. Convention itself became a remedy for opening judicial system, which was quite closed back in Soviet times and functioned within the system, being outside of any international European impact of legal discourse. Due to ratification of convention and mentioning in the law that practice is the source knowledge, when level of argumentation and the reasoning got inside the practice and reached academic auditorium. This is the great significance of convention for legal system and for legal education in Ukraine. When talking about further development and improvement, not discussing formal elements, master's degree, primary access to legal profession in connection with legal education, one should say that practice conventional law has what to offer for training legal professionals in Ukraine. Why? Conventional law, and actually what Rasim emphasized is important. The task is not to learn by heart what was the position of the court in all cases. 20,000 judgments. One cannot do it and one doesn't need it. But what conventional law can provide to legal system and legal education? Learning case law, not learning by heart, but learning the rationale, the logic of application of system of rule of law through system of human rights in practical situation to regulate relations between an individual and the state. A European court is making this balance. Learning this logic gives you possibility to reach higher level of understanding legal phenomena and training of lawyers. When talking to colleagues from Canada and USA, from their universities who had experience of cooperating with Ukraine, they paid attention to different issues, positive and negative, but what struck me most They believe that in Ukraine, we pay too much attention to words, formulation, sequence of chapters. It is significant for their work, but we don't see forest behind the trees. Focusing attention at text and words, we lose the chain of argumentation. We don't see sense and profound reasoning for making a decision and for legal assessment. So profound learning conventional law is an instrument of reaching these depths and overcome obsession of text, bringing legal sex in legal discourse in Ukraine.
And what resonates in me is the argument made by Volodymyr that for quite a while, Ukraine has been participating in the discussion of the legal discourse, but we have to be more proactive, particularly of late. The experience that we are going through as a society, the transformations that we have witnessed need to be analyzed from the legal standpoint, and we have something to deliver to our European colleagues, and we have to master the vocabulary that they are using in their discourse. And the category of the rule of law is a leading one. So we need to apprehend it, to understand it, and to work with it. And the very last argument I would like to make when it comes to the improvement of the legal education quality. Quite recently, meeting with the Dean of the Trinity College in Dublin, I noticed that he underscored that in Ireland they started studying the EU acquis fairly late. Ireland acceded to the EU in the 70s, and it was very difficult for them to catch up with the school of thought present in the EU. So studying the EU acquis together with the national legal system is not the best way. Now, because now this system is multi-layered, where there are various layers of normative regulation that should be applied contemporaneously to the same event and same circumstances. So as part of our European integration process, we have to start doing it. And on this, the efficiency and speed of our European integration hinges amongst other things. Since we've got this experience of studying the case law of the ECHR and the convention itself, so we should look for better integration and implementation of the EU acquis into our education systems, programs, curricula, and standards. And we can contribute to it. Now, summing up, I would like to say that the convention has played and continues to play a most important role in the transformation of the content of the legal education and the transformation of the legal system in general. And we need to use this tool correctly and effectively, and this can be a tool for the real rather than illusory or theoretical promotion and respect to the rule of law in Ukraine. Thank you. I don't know, Svetlana, if you heard the applause. Thank you very much for your intervention. Indeed, the legal system in Ukraine is multi-layered, and once we start learning and implementing the European layer, then we will have fewer national layers because we will discard the things that are unnecessary, that are redundant, and I think that's the way the development would take. Now, Yuri, I will now give the floor to you. All of the issues that have been raised are still relevant, and you can comment on them. But my question to you is, how do you perceive the inspiration of the students? When we were just starting engaging the student community in the Supreme Court, we saw a lot of inspiration amongst the students. And it was a driving force that has always been characteristic of the younger generations, but it has become particularly evident in the times of the war. How about students lost their inspiration, or is everything okay? Good afternoon, or is it evening already? I am glad to see my colleagues, albeit on the screen. Marta, Svetlana, Volodymyr, best greetings from the hero city of Kharkiv. The topic raised today is extremely important. That is the teaching of the convention law within our law schools. And I have to agree with my friend and colleague Stanislav Pogrebnyak saying that sometimes we are artificially incorporating something into our curricula that is not organic there. Some time ago, say 10 or 15 years ago, the chief judge of the regional court said that in each decision you have to refer to the ECHR judgments. Does it mean that in all of our courses we have to refer to the case law of the ECHR or the convention itself? Perhaps we have to rethink our methodological approaches. I belong to the Department of Constitutional Law, and I think that we should perhaps rethink our approaches. And what is close to me is that of our French colleagues, whereby they divide their course into two parts, conventional law and human rights is one part, and then constitutional law is the other. So, and now they teach, I don't know French, and I can't actually tell it to you in French, but it's the law of fundamental freedoms as far as I can understand. So the conventional law should be taught into strands, so to say. The doctrine that will be speaking about the understanding, a pan-European understanding of human rights, then national and European approaches, even though they are consonant in some parts. And then we should speak about the Constitution and human rights, and it will change the mindset of the students when they appreciate the role of conventional law in the overall legal system. And today we've been speaking a lot about the reform of legal education. I participated in this reform back in 2016, where the uniform state qualification exam was introduced. And the conventional inspiration is actually stipulated by, or stimulated rather, by some very practical considerations. The attestation procedure when the uniform exam was introduced seemed to me a good chance to see whether the students are properly qualified. And when this exam was introduced, the colleagues from the Ministry of Education and Science told me that once we conduct several iterations of this exam, then we would return to the procedure of the law test, when the primary assessment is taken or applied when it comes to the appointment to judicial positions. In Kharkiv, we spoke to legal professionals, and most of the attendees complained about the quality of the university graduates when it comes to the law schools. I say we introduce this state exam and then you don't use your qualification exams. I said that that would be perhaps a good idea, but they disagreed. And I know that my colleagues from the High Qualification Commission of Judges do a lot, and some other institutions in charge of qualification processes. And my students gave me recently the content of the qualification exam, choose 3 requirements that should match the regulation of labor, and there are certain distractors, respond to the norms and principles of the Constitution, align with our commitments under the UN Convention, etc. And here's the very practical question, whether it should be part of testing for the qualification of judges. So then, who should initiate the all-national referendum, etc.? So you will...
Тобто ми йдемо, як на мене, зовсім різними напрямками. Тобто мені видається, що ця обіцянка, я, до речі, відносно концепції закону хотів би сказати, там так само якась така, вибачте за такий молодіжний сленг, замануха є, що ЄДКІ стане обов'язковою формою чи там етапом доступу до професії. Мені там не вистачає слова «та єдиною» з точки зору перевірки знань права. Що зараз відбувається? Тобто ми говоримо про те, що валідність диплому визначається можливістю отримати первинну посаду. Коли студент складає ДКІ, а тут, до речі, ми маємо відверто говорити, чи всі студенти задоволені, точніше, який відсоток студентів хоче складати ДКІ, бо ми їх маємо переконати в тому, що це справді корисна реч. Коли він складає ДКІ, чи отримає він доступ до професії? Правильна відповідь – ні, не отримує. Тому що після цього він має пройти оці серйозні тести, він має, після того, як він знає всі юридичні позиції Конституційного суду, йому зададуть запитання, а правда, що народ України є єдиним джерелом влади? Я вже не жартую, це серйозно, в тестових питаннях при доступі. Це ж не просто вигадка якась. Тому мені видається, що от те, що ви сказали, натхнення, бажання, воно має бути обумовленим, так скажемо, тими речами, які ми студентам пропонуємо в якості реформаторських кроків. Тобто, дійсно, ЄДКІ – це достатньо інноваційна і слушна форма. Ми знаємо чудово про 2 державних іспити в німецькій системі, про бар-екзем в американській системі і так далі. Але, знову ж таки, вона має якимось чином мотивувати студента. Тобто, зараз той рівень ЄДКІ...
That should motivate students somehow. Students pass the exam on the 21st of November. That is the exam that is much higher. Answering your question, we all wish peace and victory, but this desire must be supported by development of career road of the students, reform of legal education. And very last statement, Association of Heads of Law Schools was formed. And what I want, that here I have an open dialogue.
Sincere dialogue.
I belong to a reform team.
So when we speak about the initiatives, they are not always perceived amongst
well perceived in legal community. What I'm leading to, this
amongst
reformist
the
functions
educators, and this should be part of the community of
into the
law
ones
schools.
that are
Then
adopted
it
by all
won't be
law schools.
artificial.
That will not be artificial.
We won't
shall
be
not discuss
discussing
it in
in the
closed
chats
chat how
about
bad it
the
is.
low
And there will be
quality
no
of
debate.
that.
When we
When
all share
everyone shares this responsibility,
inspiration
then
will come
the
back.
entire
Thank you.
student community would seem to be inspired. Thank you.
Дякуємо, пане Юрію. Вам також оплески, якщо ви їх раптом не почули. Ну, насправді все дуже логічно, що натхнення
Got applauds as well. Actually, you have inspiration as long as nobody spoils it. That can impact development of profession and the way legal professionals can see it. The presentations were interesting, were complete. There is no need to make final conclusions, but if you have a couple of questions, please, you may ask them. There is a question. 2 questions from students. Give them the microphone, please.
2 питання в залі, а наступні питання вже в кулуарному
2
спілкуванні.
questions from the room, and the rest will be during the dinner time.
За ваші відповіді на питання і хотілося б спитати якраз
Thank you for your answers. As regards motivation of students to continue their legal work, I heard it from Supreme Court. When you cooperate with different universities and law schools, is there motivation from other organizations like prosecutor office, local government? Do they have motivation to engage students for different internships, practices, and further employment? Thank you.
Тут можу сказати 100% є. Є запит, ви знаєте, є запит на небайдужість.
100% yes. There is a demand to take students who are interested. The task of any law school to give students a possibility to have practice and to choose the basis for practical work. It depends on the student. If the student wants to get real skills and experience, we give this opportunity of a choice. How you realize it, we shall see. More questions, please? Good evening, everybody. I'm very thankful to all presenters. I'm not a student, I'm postgraduate, but still continue studying. My question is to the last speaker, Yuri Barabash. First,
ви сказали, що ЄДКІ може як екзамен повноцінно замінити собою вступ до професій, тобто до спеціалізованих частинок, наприклад, до нотаріату або до прокуратури, я так розумію, до адвокатури. І якщо це відбудеться, чи планується, наприклад, за вашою думкою, перекваліфікація тих, хто вже закінчив освіту і вже здав ці спеціалізовані екзамени? Наприклад, як я здав екзамен з адвокатури вже там у 2020 році. Дякую.
Дуже дякую за запитання. Свого часу я був один із авторів скандального законопроекту з паном Оксаною Старій. Тоді звинуватили, була така публікація, що 5 вишів ділять недоїдений пиріг. Там хтось запропонував норму, що потрібно анулювати всі дипломи і так далі. Я уточню свою тезу. Мова йде про те, що ми прирівнюємо складання ЄДКІ до перевірки знань в теоретичних справах. Тобто це дає можливість валідизувати диплом як такий, що засвідчує певний рівень теоретичної кваліфікації. Звичайно, ми можемо тут порівнювати і дивитись на досвід провідних країн, які вже започаткували процес, коли студента атестують не в вищій школі, а студента атестує правнича спільнота. І мені видається, що це був би ефективний нормальний шлях для студента і мотивувальний, коли він знає, що склавши цей єдиний іспит, він не повинен складати, знову ж таки, мова не про спеціалізацію йде. Абсолютно потрібна спеціалізація і перевірка чи там атестація спеціальних знань при доступі до конкретної правничої професії, мова йде про перевірку теоретичних знань. А ні про яку переатестацію мова не йде, це виключається. Ну, я навіть не знаю, як це правильно прокоментувати. Знову ж таки, ми говоримо про перспективи, говоримо про те, як урівноважити ці дві речі: якість юридичної освіти та ефективний доступ до професії.
Дякую вам, пане Юрію. Щира вдячність усім панелістам за те, що знайшли можливість взяти участь у цьому заході. Обговорення показало, що насправді це дуже важливі питання, і вони цілком релевантні тим питанням по імплементації конвенції і практики ЄСПЛ, які сьогодні обговорювались. Всім учасникам хочу подякувати за участь у цьому поки що напівмарафоні, який завтра переросте у марафон. Користуючись нагодою, нагадуємо про те, що завтра в нас продовження не менш цікаве, ніж сьогодні. І Ірина дивиться такими очима, наче хоче щось сказати, тому, будь ласка, Ірина, вам слово.
Я насправді дуже коротко, але дуже важливу для вас інформацію. Але до цієї важливої для вас інформації я хочу подякувати нашим викладачам, нашим правничим школам. Вони терпляче витримали наш марафон, який затримувався, і все ж таки підключились. На мою особисту думку, правничі школи найкращі, найефективніші і найпотужніші антикорупційні органи. Це ті, хто створює суддів, адвокатів. Всі решта органи їх відбирають, давайте чесно. Але створюють їх правничі школи. Тому велика шана, дякуємо вам. І наостанок, у нас вечеря для всіх присутніх, для всіх
Now we have got dinner, and tomorrow we will have a different venue. You will have directions to the shelter. It would be more compact, but it will be safe. And if you could come tomorrow, we would be very glad. Now, everyone is invited to dinner. Thank you.